The commission resumes. Mr. Oosthuizen, you were sitting where the witnesses normally sit, but I won't swear you in.
Mr. Chief.
I accept the offer, Chairperson. Chairperson, sorry, I'm very sorry for the inconvenience. I've just received a message that the attorney for the families of the deceased is probably stuck in the same accident that delayed me. He, according to his SMS, he'll be here at 9:30. At 9:30, Chairperson. I'm not saying anything. That's what he.
Sorry, I must put on record. Are you agreeable to our starting before he comes, or do you want us to wait till 9:30?
Okay, Chairperson, I'll take responsibility. We can start.
You take the responsibility.
Yes.
Thank you. To that, we did indicate times for council, an hour and a half for the applicants, hour and a half for all the respondents who wish to speak, and then half an hour for the applicants in reply. So effectively that means you will argue, you and the attorney, when he comes, will argue until about 11:15.
Quarter to 12.
11:15. And thereafter, the respondents will argue till 12:30, and you will have till 1 o'clock to reply.
Chairperson, I'm very sorry about this. Can we just stand down for 5 minutes? I now just got another message that my attorney might be involved in an accident on the way here. Can we just...
We will adjourn for 5 minutes.
Thank you, Chairperson. Did you see her just now? Yeah, just now. Thanks. Thanks again. Can you see Sisoma Pulo's kind? I hope it's not her.
In fact, now I was expecting something like this. I checked my I was so relieved. For some days you're late.
Commission commences.
Yes, Mr. Profri, you explained to me that the attorney hasn't come, but you again took the responsibility on yourself to say we can proceed without your attorney. You can tell your attorney when he comes what happened in his absence.
Yes, thank you, President. Well, the position is it's the attorney, Mr. Nsabeza's attorney, but my attorney who was supposed to be involved in an accident, I'm not able to reach her. So, but other people are trying to get to the scene.
Well, I hope that she wasn't injured.
Yes, we hope so. Someone has gone to the scene. Thank you, Chairperson.
We'll have to adjust the time allocations to allow for the fact that we lost half an hour, but we won't penalise your side or the respondents to that matter.
I'm indebted to the Chairperson. Thank you, Chairperson. Chairperson, what I will do is not to repeat the grounds of the application insofar as those were outlined in the address that I gave last week. And maybe to save time, what I will do is to deal with some of the issues that have been, or rather the points that have become issues, as it were, either because I had raised them or because they are raised by the opposing parties. So, as it were, hopefully that will make me save time when I have to do the reply, because in a way I'll be having two replies, because I'm going to deal with the matter that is raised in the answering papers, as it were. Thank you, Chairperson. The first issue, Chairperson, is a preliminary issue of the opposition that is being advanced on behalf of the Department of Justice. As it were, we have three parties that have indicated opposition, or rather two parties and the department. And all I need to say about the involvement of the department at this level is that it is very unfortunate and inappropriate. The Department of Justice, as we all know, is not a party to the Commission.
Department of Justice.
And the nature of the Commission is that the President has delegated, so to speak, to the Commission the procedure and everything to do with how the Commission should run. And in terms of the law, the President, even in appointing the Commission, has to act personally himself. Now, it is also true, of course, that in terms of the operational arrangements for the Commission, the President can take advice from one of his ministers or any of his ministers as he wishes. But that does not mean that there's an implied delegation to such a minister to participate directly in a commission. That, I think, goes against everything that is sought to be done by appointing an independent commission and even going as far as to appoint a judge, a retired judge, which and independent advocates to assist the judge. All those measures are taken to assure the public and the participants of the crucial issue of the independence of that commission. Now, if that independence is going to be threatened by either the president or one of his ministers, literally descending into the arena, which is what they're doing, that can only have the effect of undermining that independence. Because then they might as well have run the commission or the investigation themselves and not give a fiction of independence which can be withdrawn at will. So it's regrettable that the Minister of Justice can see it fit to come here effectively and intimidate the commission directly, in a matter that involves the parties and that is full, even on their own version. That matter is fully within the discretion of the commission. The minister, in the affidavit supposedly done on his behalf, says, firstly, at 6.4.2 of his affidavit, the refusal of a postponement by an investigatory body cannot, with respect, infringe upon the procedural rights of the applicants for postponement. That's a matter I'll deal with when we deal with the merits, which is wrong. But he goes on to say that we submit that because of the legal nature of the Marikana Commission, it is the convenience thereof and its obligation to report to the President that comes first. There is thus in reality only one interest to consider, that of the Marikana Commission, and not competing ones. And then they say, in any event, the grant of a postponement, whatever the nature of the discretionary power, is an indulgence, and so on and so on. So what they're really saying is the truth, which is that, in the last part, that this is a matter that is discretionary, and that discretion by law and by also in terms of the terms of reference is a discretion that is fully in the hands of the Commission. So the Minister of Justice cannot directly himself come and fetter that discretion. I see that my learned friend Mr. Oosthuizen is here, presumably to argue on behalf of the Minister. He is the person who, in the litigation, is acting for the Minister of Justice and the President of the country. So I don't know what hat he's wearing now. Is the President also here to oppose the postponement?
Mr. Oosthuizen, who is your client?
Jay, I represent the department today. I'm on brief from the State Attorney for the Department of Justice and Police.
You're not appearing for the President?
I'm not briefed for this matter on behalf of the President. Thank you.
Right. Well, in that case, the Minister, if he's here in his own right, can also only be here because he's been delegated by the President, because the Commission belongs to the President. The Minister's role in the whole business.
I'm sorry. He's acting for the department. I understand the political head of the department is the Minister, but he didn't say he's appearing for the Minister as such. He's here for the department. This is what I understood him to say. So,
yeah, well, that's a fine point.
It may make no difference, but I just...
No, it makes no difference whatsoever for the purposes of what I'm saying. The department, whatever, any state organ that is directly involved with the executive, it is the point of the matter is that the Constitution gives executive powers to the President to appoint a commission. The President then delegates delegates the running of that commission to you, Mr. Chairman, and your commissioners. That's the point I'm making. So any other executive arm of government that seeks to interfere in the commission as a party, as it were, quote unquote, and to come and tell us whether there should be a postponement or not a postponement, that is direct interference by the executive. That's the point I'm making. Because the power as to whether there should be a postponement or an adjournment, how long a witness is going to be, whether a question and cross-examination is going to be asked, all those have been delegated to you and your commissioners. What is next? Is the executive going to come here and tell us which questions should be asked or not? This is very improper and unprecedented and ill-advised, and it sends a chilling effect insofar as it is meant to intimidate anybody. Not that I believe that the intimidation is going to work, but the attempt alone is abhorrent. Now, so my take, Chairperson, is that the matter of the postponement or non-postponement of this matter, pending in terms of the relief we prayed for, is a matter that concerns only the parties to this matter, and also the commission itself, and should be determined without the direct involvement of any executive arm of government. And I suppose the chairperson will have to make a ruling on that point. At whatever point suits the chairperson. Let me just add this. The situation that we have now is the following. We were informed at the meeting, as I said earlier, that the evidence leaders will oppose the application. I think they've decided not to, and I think they're well advised not to. But, so what has happened now?
I thought I saw Mr. Budlinder shake his head. Perhaps we should get clarity from him at this stage.
Okay, maybe he's not as well advised as I thought.
What stance he is going to adopt, and whether he's going to take the good advice that you suggest he should take, or possibly some bad advice of his own. Mr. Budlinder, what is the stance of the evidence leaders going to be?
The evidence leaders, Chairperson, will submit that there's no basis for a postponement, and the application for postponement should be refused.
So you withdraw your comments about his being well advised, and you now carry on with the argument.
Yes, well, yes, I'll withdraw. I won't say whether he's well advised or ill advised now. I'll just withdraw the comment. Well, that makes the matter even worse than Chairperson, because what we really have here is a situation where you have the evidence leaders appointed by the Department of Justice.
It's not correct. The evidence leaders were appointed by the Commission. We chose them. We told the department to whom we wanted to be briefed to be evidence leaders, and they had no say at all in the matter. We told them what we were proposing to do, and they accepted it. And these evidence leaders are people chosen by us, not appointed by the department. So that's a very important point to have that on record. Briefed, as I said, by the state attorney, but appointed by us, not the department.
Okay, then I'll amend it. We have the evidence leaders who are on the payroll of the Department of Justice.
Chair, I object to that.
I'm not sure that counsel who
I'm sure
from the state attorney can be regarded as being on the payroll of the department.
They are.
The Department of Justice is obliged to put the state attorney in funds so the state attorney can pay counsel. But on that argument, the commissioners are on the payroll of the Department of Justice as well, because they've also got what amounts to...
Well, that's a different matter.
Chair, can I just say that if we've tried to conduct this on a civil and cooperative basis, but if there are going to be allegations that the evidence leaders are not acting independently and that they're acting on the instructions of the Department of Justice, I would like our learned friend to say that and to justify it and to take the consequences.
Well, if I was Mr. Butland, I would have waited until I say that. There's no point in him saying it for me.
So, are you not saying that?
No, of course I have not said it. Or how can you object to something I have not said?
We'll be satisfied then.
Let me tell you what I am saying. What I'm saying is that, not me, by the way, what the Department of Justice says in its affidavit is that the amounts coming from the budget of the department are 2.2 million per month for the running operational costs of the commission and 4 million per month for legal fees. Paragraph 5.3 of the affidavit. So let me not say anything, I'll just read what the department is saying. And
I'm sorry, I don't understand where they take you. Presumably, because I have been recalled from retirement to preside over this commission, I'm paid an extra salary for that purpose, not the full salary, but because certain allowances aren't paid twice. But presumably what I'm paid also comes from the department's budget.
Yes.
So on your argument, then I'm also on the department's payroll.
No, Chairperson.
So,
if I may, okay, maybe I should read this thing fully so that you can appreciate what the point I'm making. It says, in general terms, the department, that's the Department of Justice, has already expended some 32 million on the Marikana Commission in the previous financial year, whilst the current year we have already expended some 24.7 million rand. They're giving a total of some 54.7 million rand to date. The average monthly operational cost of the Marikana Commission, and to cover your point, it says, this covers your point, Chairperson, so to show that that has nothing to do with the commission. It says, in brackets, excluding the legal fees payable to the commissioners and the evidence leaders is some 2.2 million per month, whilst estimated legal fees are some 4 million rand per month. Now, what I'm saying is that we accept that for practical purposes there are other operational costs and the commissioners have to be compensated. That's not what this is about. What I'm saying is that the part of this 54.7 million, that's the payroll I'm talking about, is the fees that are paid for the evidence leaders. In any event, it doesn't matter, Chairperson. I'm talking about perceptions. My client's perception is that, firstly, the Evidence Leaders Association, direct or indirect, with the department is there, is established in the paragraph that I'm talking about. Number one. Number two.
Mr. Chairman, can I please ask that we be shown in the papers before the Commission where this perception is canvassed in the papers and where we had an opportunity to deal with it in our affidavit. To make this,
I think that's a point you can make in reply. I think let Mr. Mpofu argue his case. He's subject to time limits. Let's be fair to him. Allow him
no, Chairperson, I think that's
argument without unnecessary.
Yes, yes, thank you. I appreciate that, Chairperson. And quite frankly, that intervention is startling, because the department, in its affidavit, has dealt with this issue. I don't know why they dealt with it if they didn't think it was raised. It's dealt with in paragraph.
I'm sure they raised with it. They dealt with the
paragraph 2, 3. Yeah, that's because I raised it.
The perception point, but your argument, I take it, is the perception is based upon the statement they make.
Yes. No. Well, no. Just a minute, Chairperson. Yes, start with up to paragraph 5, including the part that I was reading.
You rely on paragraph 5 of the department.
Yes, yeah, but all the paragraphs even preceding that deal exactly with this point. So either they were prophetic or it was raised before. And I submitted the latter. To their knowledge, the issue was raised by me. So that's the first issue, Chairperson, that we need to raise. As I say, either from a point of view of propriety or from the legal structure of the Commission itself.
Let me make sure I write that down. So far, you've been addressing us what you call the first issue.
The preliminary issue, yes.
Yes, and you argued that it was unfortunate, and you used, I think, stronger words than that the department had seen fit to intervene and to oppose. Now, can you give me in one sentence what the first issue is so that I can...
Yes.
I tried to write down what you said, but I didn't
yes.
get it all. Yes. In one sentence or two.
Thank you, Chairperson. Well, what I'm saying is that in terms of the constitutional powers that are at play, which the President has delegated the powers to determine the issue that we've put here to the Commission itself, and it is improper and inappropriate, and and ill-advised for the Department of Justice to appear in this commission directly to influence whether or not a postponement should be granted or not. I think that would be, in a nutshell, the submission. And it's a matter on which we seek a ruling.
Is in terms of the constitutional powers at play, the President has delegated certain issues to be determined by this Commission. Including the issue at hand. And it is improper and inappropriate and ill-advised for the Department to appear in this Commission and seek to oppose the postponement. Is that what you say? Directly. And it is a matter on which we seek a ruling. Yes. What I suggest you do is present your whole argument. Okay. I will then ask Mr. Westhuizen to reply on that point only, and then we'll give a ruling. Hopefully he can do that before the tea adjournment. We can consider it over the tea adjournment, and if we have come to a clear view on the matter, well, then give the ruling that sought one or the other after that, and then we can carry on. But argue in the meanwhile your whole argument. The rest, yes. Thank you, Chairperson. Right. Now, moving on to the second issue. Yes, I'm now moving to the merits of the merits. Yeah, there are a number of sub-issues there, as it were. Is that right? In the merits? Yes. Oh, yes. What's the first issue on the merits that you want to argue? Right. Okay. As I said, Chairperson, I will... may I ask you, do you have a note, if I ask you what the issues on the merits are, if you can give them to me in summary, almost like headings, to make it, because you haven't given us heads, but I understand the problems with it. But can you just tell me shortly, the headings, as it were, of the issues that you're going to deal with in the merits, so I can write them down and then better follow your arguments? Yes. Yes, I'll attempt to do so, just cleaning on my notes, Chairperson. The first kind of cluster of points that I'm going to make will be points that are taken from the answering affidavits, mainly the one of the Department of Justice. So I'm going to have to assume that the Chairperson is going to take it into consideration. You can assume that we've studied all the papers filed by all the parties, including the transcripts of what you and the attorney for the families. Yes. And that, what I call that cluster of issues, Chairperson, deals with some of the factual allegations made there regarding the number of witnesses that are still going to testify, the need for closure, and the effect of the outcome of the Commission on pending civil and criminal proceedings. I'll deal with those, as I say, as one cluster. This pending civil proceedings. Pending civil and criminal proceedings. Yes. Then I will deal with
what would seem to be the nub of the legal issue raised by the department, namely that the refusal of a postponement cannot infringe upon the procedural rights of the applicants.
Applicants, I take it you mean your client. You mean your clients, not the
main applicants,
not the solidarity applicants.
Yes, the main applicants. I think somewhere in one of these affidavits there's been referred to that. So I'll adopt that that nomenclature. Then I'll point the chairperson to a series of what I call misrepresentations of fact upon which the opposition is based. Then I'll deal with the allegation that says the participation of the applicants, of the main applicants, is not essential. And I'll deal with the allegation that such prejudice that the main applicants might suffer would be cured by the so-called cross-examination of the witnesses by the evidence leaders. And then there are 2 points, excuse me, Chairperson, I'm trying to edit as I'm going along. There are 2 points which probably belong to what I call the legal issue. One is that there's an allegation made that the findings of the Commission are advisory, and I suppose it means, therefore, no rights will be infringed. So we can take it as part of the earlier point.
There were 2 points which belong really to the legal issue. The first one is that the findings commission are advisory at that point. And
yes.
What's the other one?
The other one is Chairperson, okay, it will be infused in the second point. Yes, these are what I call the legal points. Yes. That's basically the landscape.
That's a summary of the points.
That's the summary of the points.
Some of the points you're going to raise, and you've identified the issues.
The issues,
which
yes.
I've been able to write down. Thank you. And now you're going to address the points.
The points, yes. Thank you, Chairperson.
Keep an eye on the clock, because you've got until 11 o'clock.
Thank you, Chairperson.
We will endeavour not to interrupt you. I just was seeking clarity on the issue.
That's important.
If there are interruptions, I have to allow you injury time, but I hope that won't arise.
Thank you, Chairperson. Thank you very much. Well, the issue I was going to start with, we've already dealt with in another context, which was the issue of the spend. I've already read that out, so to save time, I'm not going to go there again. There is an allegation which I want to note about at 5.4.1, that says that there are still 28 witnesses to testify. 22 have already testified and 28 witnesses still to testify. 5.4.1. And just in passing, Chairperson, if I may deal with that issue at the same time as I deal with an issue raised in SABC. My approach really is that some of the issues overlap. They've been raised by SABC and they've also been raised by the department. So I'm not going to address them individually. And in fact, even there's an affidavit from BAPO, but they also raise the same issues. The evidence leaders can do it and so on. So it's one issue. Now, SABC takes what is a kind of technical point in limine where they say that strictly speaking, the lifespan of the commission is till the end of October. And therefore a postponement cannot be allowed, which will have the effect of not finishing on that date. All I want to point out is that
I'm sorry, Mr. Mbofu, forgive me. There was something I meant to ask you at the beginning, which may be relevant on this point. And that is, we were told in chambers, and you conceded it, that the relief sought in the main application in the High Court is subject to an amendment. And I think you should put that on record, because that may have a bearing on some of the arguments.
Yes.
I should have asked you that at the outset. I'm sorry.
No, thank you. Actually, Chairperson, this other issue that I didn't want to canvass deals with that. Yeah. Firstly, it deals with that, but it also deals with some distortions of the meeting that we had with the Deputy Judge President, which appears in this affidavit.
There's a problem there. Affidavits has been filed by the department, setting out allegations about what happened at the meeting. You didn't choose to file a reply dealing with that. So is it permissible for you to seek to traverse from the bar allegations on oath which have not been challenged by any affidavit filed from your side?
Yes, it is.
How can that be so? Because
firstly, the special procedure that has been allowed in this particular application.
Special procedure related to allowing you to tell us what your notice of motion would contain orally and what amounted to the founding affidavit. There was in fact no affidavit, but that was the point that nobody took. Effectively, what would have been in the founding affidavit, you also told us orally and it was transcribed. The department filed, other parties too, filed affidavits. You chose not to reply to those affidavits. I'm not sure that one can permit a party who hasn't filed an affidavit traversing what's said in an affidavit filed by another party, then to challenge the content of the affidavit from the bar.
No,
and in any event, if it were to happen, the question that arises whether the Pascon-Evans rule applies, but I take it we don't have to get there. If there's no affidavit contradicting the only affidavits on the point which are before us.
No, well, Chairperson, firstly, that's an overly technical approach. Our understanding is that the affidavits, such affidavits as we were to file, whether they were filed...
I told you last time,
yes,
if you raise your fingers in the air to indicate quotation marks, the transcribers won't pick that up.
Yes,
so please, if you... Once put something in quotation marks, make it clear on the record that's what you're doing.
Thank you, Chairperson. Yes. Well, okay. What I meant is really that our understanding of your earlier ruling was that such affidavits as would be filed on behalf of the applicants would be done in the same manner. We never understood it that the filing affidavit could be done from the bar, but the replying affidavit cannot be done from the bar. Neither when we got the...
Are you... If what you're telling us now from the bar counts as an affidavit, then it's got to be on oath.
Well, it's not an affidavit. I'm telling you the meeting that I attended as an advocate, Chairperson. If I cannot tell you as an officer of a meeting in which I participated,
sorry, excuse me a second,
with no less than the Deputy Judge President, then we're in trouble.
You see, the problem that arises is there's now a dispute of fact. You were raising a dispute of fact as to what happened at the meeting. And the dispute of fact is a dispute which arises from an affidavit on one side and certain remarks made from the bar on the other. But even if one says, being non-technical as you suggest one should be, that the statements made from the bar in reply to the affidavit don't have to be on oath and still are sufficient to raise a dispute of fact. The fact is, there is a dispute of fact. Now, if there's a dispute of fact, how can we determine the matter what approach would be appropriate in your submission?
Well, Chairperson, maybe...
The reason that the question, this particular dispute of fact is important, and not one that can just be swept under the carpet, is the dates are important in that regard. And what is said, whether said on oath by the department, is the dates were only provisional. Now, that you say that's not correct.
That's not true. I'm not saying that.
But how can we, sitting here in the commission, decide that dispute of fact, where we have an affidavit on the one side, and let's call it a quasi-affidavit on the other, which raises, or virtual affidavit, which raises that dispute. How do we resolve that dispute?
Yes.
That's my question.
Okay, I'll tell you how you resolve it. It's not a question of a quasi-affidavit only. There's a letter from no less than the Deputy Judge President that outlines what happened in the meeting with him. So, and that letter you've got, everyone here has got, it's dated 28th August. Here it is. If the Deputy Judge President must do an affidavit, well, then I'll go and ask him. But the issue is that what happened at the meeting is captured there. And what I was hoping to do is to tell you from the bar of what happened in the meeting. Fortunately, my learned friend, Mr. Oosthuizen, who is also a member of the bar, is here, who was also at the meeting. And if what I say happened in the meeting in his presence, if he disputes that, then we can deal with the matter. But for now, that if I, who is a member of the bar, was at the meeting with the Deputy Judge President, and my opponent, who was a member of the bar, was also there, if that what happened, and there's a letter from the Deputy Judge President, Nochal, if that doesn't resolve what happened at the meeting, nothing ever will, except calling the Deputy Judge President.
I'll let you proceed with your argument at this stage.
Thank you.
We'll hear perhaps what Mr. Oosthuizen says about that if necessary.
Thank you.
Sorry?
Thank you.
But before, he wants to say something. Before I hear what he has to say, can you not perhaps tell me the other point that I raised with you? I understand, and you conceded that, I think, in Chambers this morning, that the relief sought in the High Court, whether it's going to be heard provisionally or definitely on those two dates is a different matter, that the relief sought has now been expanded. Is that correct?
Yes, there's a notice of amendment which has been served in terms of Rule 28, Chairperson.
And what is the nature of that amendment?
Well, the nature of the amendment, off the top of my head, it's probably here, is firstly, the most important thing is that it is, in our view, an amendment that does not necessitate the supplementing of the papers, because those issues are canvassed in...
No, I just want to know what the relief...
Well, that's what I'm telling you is in the document. I'm explaining what the document says.
Carry on.
Yeah. It says that it does not necessitate the supplementation of the papers because it deals with two issues. One, which have been canvassed in the founding affidavits or in the papers as such. The one issue is we say that although our main argument is that the Legal Aid Act does provide for the granting of assistance in commissions. And as proof of that is the fact that the Legal Aid Board assisted in this commission in respect of the deceased families. So unless if they were breaking the law, the Act must allow them. And in any event, they've considered that point. They said they were acting in terms of some discretionary power. So that's our standpoint. But we're saying if we're wrong on that standpoint, then to that extent, the Legal Aid Act would be unconstitutional if indeed it does not allow for legal aid assistance where injustice would result simply because of it's a commission or it's this or that or the other. That's, in a nutshell, that's the First Amendment.
Are you asking then for a declarator that
Yes.
the Legal Aid Board, insofar as it doesn't permit legal aid to be given for commissions, or possibly as of right for people who are appearing in commission, is unconstitutional?
That's the first part.
And although, of course, if that were granted, the case would have to go to the Constitutional Court to confirm that declarator, would it not?
Yeah.
Okay, so that's the one amendment, and the other?
That's okay. The second amendment, Chairperson, is that the refusal by the first, second, and third respondents, who are the President, Minister, and Legal Aid South Africa, the refusals, so to speak, or their decisions not to grant legal aid, should be set aside on the basis of irrationality, which is a ground that's based on the rule of law. In other words,
so effectively you're seeking to review those decisions.
And set aside.
Yes, yes, obviously review.
Yes. But the crucial thing really is that
Sorry, let me just write down quickly what you said and then you can carry on.
Okay.
Thank you. Please carry on.
Yes.
Sorry, may I ask you this? You say you filed that amendment in terms of Rule 28. I take it as a notice for them to oppose if they
object if they want, yes.
Okay, I see.
But I'm sorry, as you definitely sitting up there know, an amendment can even be raised at the hearing. The point that we have done here is to say that, let me put it this way, we can't second guess whether it will be objected to or not. If it is, it will be obviously debated on the 25th before anything else happens on that day. That's really the bottom line here.
Mr. Oosthuizen indicated he wanted to say so. I'm not sure what it is, and I'm sure we'll allow him to say it, but I've got to first hear what he wants to say before I decide to let him speak or not. Yes, Mr. Oosthuizen, you wanted to intervene at one point.
Mr. Chair, in order to assist my learned friend, and just to make it clear, I drafted the answering affidavit of the department. I was at that meeting before the Deputy Judge President, together with my junior Madiso.
Okay. So now what you're telling me, there is a dispute of fact.
There is a dispute.
Okay, thank you. Yes. Mr. Pofu, please carry on.
Yes. Okay. Well, let me then jump quickly back to that issue.
So your argument is that whether it's right or wrong is not presently relevant. Your argument is that the contentions raised by the department are contradicted by the letter of the Deputy Judge President. That's your argument.
And they're also contradicted by what actually happened.
Well, deciding what actually happened, we have to resolve the dispute of fact.
Yeah.
But your argument is that the letter of the DJP is decisive the issue and effectively eliminates the dispute. That's what I understood you to say. I don't want to put words in your mouth.
No, you're right.
If I understood you correctly, that's your argument.
I'm happy with that.
If there's anything else you want to add in that point, you can do so, but that seemed to me to be your argument, which we understand. Whether it's right or not.
Well, I can add something else, maybe, now that Mr. Oosthuizen is here, which is that on Tuesday, I spoke to him, and fortunately I was in the presence of three other colleagues, Mr. Vani, Ms. Barnes, and Ms. Lewis, about their request, which they had asked me to convey to him, that their heads should not be filed today, but on Monday. And Mr. Oosthuizen told me that all the heads must be filed today, which is in line with the letter of the DJP, because he has an urgent matter next week. He never said anything about provisional or what am I talking about, what heads am I talking about.
That's the extra point you added.
Yeah, that's the extra point.
Okay. Now you want to go back to the point you were debating a moment ago?
Yes. Right. The point really was that the idea of SABC saying that taking that technical point is directly contradicted by the department's view that there are still 28 witnesses. I think that what the department's view is more accords with the reality, which has been articulated here, which is that the commission is not going to finish on the 31st of October. Whatever we do, and even if we sit 24 hours a day. So that point in limine can be discarded on that basis alone. Then, Chairperson, if I can just take you back to what you said. At the very beginning of this matter, on day one, on the 1st of October, you were also told that it's our view that this process is, in a sense, a mini TRC, which is meant to bring the truth and reconciliation, is quote-unquote outlandish. And I just wanted to make it clear that we took that outlandish idea from what you said, Chairperson, at the beginning of the commission, which was that you do your work in the firm belief and conviction that getting to the truth of what, how, and why it happened will be part of the healing and restoration process, which is so necessary. As Commission, we will do everything in our power to make sure that your attendance and participation, underlying participation, in this inquiry will not add to your grief and trauma. It is for this reason that the Commission has deemed it fit to subscribe to the values of truth, restoration, and justice, which were adopted in our official logo. And then later on you said, it's very important that the truth, insofar as what happened over the period, should become clear as soon as possible. We have to balance the need to deal with the matter with expedition, with the need to be thorough, and we certainly want to give everyone concerned the assurance that we'll do so to the best of our ability and so on. I have no doubt that you remember that. The point being this: if you look at the opposition from whichever quarter to this postponement, it negates exactly what the chairperson said the commission was about, which was the balance between expedition and effectiveness. Let's call it that. All that you get in all these pages here is about expedition. Everything that is said is about this must be finished. The minister says this must be finished because foreign direct investment is threatened, the reputation of our mining industry, and all sorts of things like that. But the point is that if you read all the documents, they deal simply with one point, which is expedition. Now, our simple answer is that the commission has to take into account what you, Chairperson, correctly said it should be the focus of the commission. Expedition, yes, of course, we can't argue with that. But expedition to what end? Are we going to come here and say we must just finish the commission so that we can pat ourselves on the back and say we finished in record time, and have an outcome that is discredited, that does not achieve any of the goals set out in that logo behind you, the truth, restoration, and justice? Then if we do that, then we might as well stop the commission right now, or rush it through so that we can say we finished expeditiously. That can never be the point about an exercise of this nature. An exercise of this nature must be finished as soon as possible, that we concede. But it must achieve its ends. And it cannot achieve its ends if the victims are being shut out of the door. It cannot achieve its ends if the victim's right to participate, let alone anything else, just participation. Because as you said, Chairperson, the participation is that
sorry. When you finish your argument, my colleague Lukotti wants to ask you a question.
And Chairperson, I don't want to go back to things that I've already said. The point here is that one should conceive of what I call the right to participation, almost as a standalone right, irrespective of the outcome. And that's really what I've been trying to say, which is being denied. Or maybe to even put it properly, the right to meaningful participation, which is enjoyed by all the other parties who have money to do so, to participate meaningfully. That's really the bottom line. And we have said, Chairperson, there's a criticism that this might be a never-ending saga of postponements. We have said here last time, responding to a question, I think, which was put by yourself, Chairperson.
In response to a question by Mr. Budland, you made it clear.
Oh, yes, it was Mr. Budland.
You are only asking for postponement until the outcome of the proceedings in the High Court.
Yes, and we would come back.
If the case goes further, you would not wish the postponement to follow the further progression of the matter after the High Court. You made that clear.
Thank you.
In response to your question, Mr. Vice
Yes, thank you, Chairperson.
You're approaching near the end of your time. You are on the last point, so...
yeah, Chairperson, I'm finished. I'm actually finished. I just want to round off by saying that, as we said last week, the decision on your shoulders is not an easy one, because it's, as you said on day one, you are weighing up two important criteria, as it were. But let us not be unmindful, Chairperson, that we're dealing with people who are aggrieved here, who are, simple people, uneducated. We have to be forever explaining to them why, when we have said that there's a postponement application, for example, the Commission is still continuing and churning out witnesses. And, there comes a time when we also run out of explanations about these things. We do our best to make sure that the integrity of the Commission and its outcomes is protected. But if these people who have really been disadvantaged from day one, or even before day one of the Commission, starting from the days when they were arrested for the murder of their comrades, if people who have been disadvantaged from then are not given a simple request of a postponement, which might have, looking into posterity, the effect of having a commission whose outcome is acceptable, whether, as one of them said yesterday, all we want is the truth, whether that truth is for us or against us. But we want the truth to be out. And that's really all they're asking for, Chairperson. It's an opportunity for them to assert the truth, or for the truth to be asserted against them, if there's such a thing. But there can never be any reconciliation, as they say, without justice. And there can be, or rather, no reconciliation without the truth, and there's no truth without justice. And those are issues that are covered in your objectives, which is where I started, in the logo behind you: truth, restoration, and justice. And what is happening here is unjust. And it will never result in the truth. Thank you, Chairperson.
Thank you, Mr. Mbovu. Advocate Tukoto wants to ask you a question. He did a minute ago, and that he still does.
Oh, sorry, Advocate, if I can just make one last point. Seeing that my learned colleague has not arrived. Is he here? Oh, okay. Are you going to cover the fact that he didn't answer? Okay. Oh, Mr. Musigidi is here. So I've told him that I've eaten up most of his time. So
eaten up all of his time.
Yeah. So maybe then I'll deal with the question, and then he can say his piece. Thank you.
Yes, right. Okay, Mr. Kosa will now ask you a question.
Now, all I want you to, you don't have to deal with the merits of that application for the review. I just want you to respond to this allegation of the SABC affidavit in paragraph 31, where they say that the prospects of success in that review application are poor. What's your summary of your response to this?
Yes. Well, Chairperson, I think it's arrogant, to say the least, for the police to say that. The fact of the matter is this. And it also comes from one of the things that was said by the minister there in his statement, that the application was rejected, wara. The point of the matter is, I'm saying this for the third time, the only issue that was determined by the court was whether or not we are entitled to interim relief so that the commission can continue while the main application is being debated. And the court found in the High Court and also in the Constitutional Court for technical reasons, because it's interim relief, that it had to defer to the High Court. The Constitutional Court said it had to defer to the High Court. But apropos the issues we're debating here, the Constitutional Court made it clear, the statement that the chairperson and I were referring to now, that it is patently unfair and would compromise the outcome of this commission if the situation that I've described is allowed to continue. And that's really, we're simply saying that. Yeah. So nobody knows what's going to happen in the application. And in any event, the application is not, the review is simply the amendment that I was talking about. The application as it stands now is for a declaration of unconstitutionality based on sections 34 and 9 of the Constitution. And the prospects of success, as we say, in my book, are good. They are good because, for example, the differentiation between deceased victims and injured victims, even our chairperson here said was puzzling. It might be equally puzzling to the High Court. And we go more than to say that it's puzzling. It's irrational, we say. And on the basis of the irrationality of the differentiation between victims, because the one is dead and the other one is alive, that offends should offend anybody's sensibility of the notion of equality. Because the only reason really is that the assistance is not being granted cannot be reconciled with the attainment of justice, which is what both the Legal Aid Act and this commission should be committed to do. So we do think that when the merits are discussed, and also in terms of Section 34, the only defenses that have been given are that no rights are affected, which I've dealt with already, because that's just out there. And the other defense that has been given is that the commission is not a court, which also has been covered by many cases, that if a commission, that particularly one that adopts a quasi-adversarial approach such as this one, that the notion of fairness must not just notion of fairness as described in Section 34 of the Constitution should be imported there too. Thank you.
Thank you.
Okay, well, speak after tea. Okay, sorry, I'm just a mess. Mr. Musigidi would prefer to say his little piece after tea.
How little is his piece?
I don't know.
Chair, I wouldn't call it that little, but it wouldn't be more than at least 5 to 10 minutes, Chair.
We did indicate in advance, and I understood it was accepted by the parties, that the applicants can have an hour and a half, the respondents an hour and a half, and then half an hour in reply. Now, that is what we said. But, all right, I'll give you 5 minutes after tea. 5 minutes.
Chair, thank you.
We're now adjourned.
If you're done, we can small share. Small share. Okay,
How are you?
Fine, and you?
Fine, thanks.
We are back again.
Yeah.
Yeah, okay, I just need to.
What time do they start again?
Listen to one of these big shows.
What's that?
Yeah, okay.
So I said, I'm going to do it. Is while I'm here, I have to go and finalize and okay my head. That's the problem of working alone.
That's all I have to say to you.
I'll take the chair.
And you must admit it was eloquent.
He's got gout in his big toe. Ek lag my dood vir hom.
Wat is nou?
Charles, the irony is that that is an affliction of the wealthy.
Do you think that's the rich man's disease?
Somebody said it, yeah.
Affliction of the wealthy.
The Commission resumes. Mr. Shorzy, you're going to speak on behalf of the... Who's speaking on behalf of the... Mr.?
Musikili, Musikili on behalf of the families of the deceased.
You are quoted in the transcripts as being Mr. Shorzy, which of course is a mistake because Mr. Shorzy appears for one of the other parties. Tell me how you spell your name. I'm afraid I didn't get it correctly.
It's M-O-S-I-K-I-L-I, Chair.
You're going too fast for me.
M-O-S-I-K-I-L-I.
Musikili.
Musikili, Chair.
Yes, forgive my not having your name correctly. Sorry? Yes, Mr. Musikili. I said I'd give you 5 minutes, but you did say 5 or 10, and if there's something important you want to say that takes you 10 minutes, you've got 10 minutes. But you don't have to use the full 10 minutes if you don't want.
I'm indebted, Chair. I will try not to use up the whole 10 minutes, and I will try by all means, Chair, not to repeat submissions already made by my late colleague. Chair, one thing I am aware of, Chair, is that we can argue this case of this postponement case, Chair, till probably Jesus comes. But what I'm certain of, Chair, is that as things stand, and those who instruct me, Chair, we are aware that the Commission can indeed proceed without the minors and without the families, as it has indeed done so. Chair, I say this because, Chair, I too, Chair, have confidence, Chair, in the evidence leaders and the commissioners that are presiding before this commission. However, Chair, the question today, Chair, is not really about can the commission proceed without the minors or not, Chair. The question that we are dealing with, Chair, is not even the question of prejudice or expedition or balance of convenience or the integrity of the commission, but rather, Chair, we are dealing with the issue of fairness, Chair. Amongst others, Chair, we submit that the commission needs to be seen as a caring and a fair commission at the end of the day. Now, Chair, it is common cause, Chair, as to why the minors themselves have withdrawn from the commission, Chair. And, Chair, we submit that, Chair, they did not withdraw, Chair, because they are worried about the integrity of the commission, or they are worried that the truth is becoming unbearable, or for any other reason for that matter, Chair. But they simply withdrew because they don't have money, and that's the only reason why they are not at this commission, Chair. And, Chair, unfortunately, Chair, as we see things and as we have engaged with the minors, the situation is that they see themselves at loggerheads with the South African Police Service, who are beefed up with legal representation and who have actually raised a legal defense to the whole Marikana saga. And for them, Chair, to not have any funds set aside to beef themselves up or to prepare themselves for their case is quite unfortunate. And, Chair, to those who instruct me as well, Chair, they also, Chair, are worried that they too are poor, and the way they have, at least the other poor people have been treated at this commission, it's not fair at all, Chair.
Your clients have got legal aid.
Chair?
Your clients have got legal aid.
That's certainly correct, Chair.
Your clients are not just the families, many of the families, of course, involve minors, and I take it that your clients have, certainly the minors and their guardians, in their capacity as guardians, would have a constitutionally entrenched right to legal aid.
Indeed, Chair. But, Chair, the point is this, Chair, and this point, Chair, I tried last time, Chair, when I was making my deliberations at length, Chair, to set out the reasons, Chair, as to why those who instruct me have also withdrawn their instructions. And, Chair, we submit that they did not only withdraw out of solidarity, Chair, we gave reasons as to why they too, as much as they have legal representation, they feel that their continued participation at the commission without the minors is indeed meaningless, Chair.
I understand that you. I think I understand what you are saying. It's essentially based upon the statement by Ms. Zaneka Nungu, which you read to us, which appears at pages 13124 and following of the transcript. You don't have to repeat that because we've read it and studied it. If there are points, of course, that you want to stress and highlight, you're free to do so. But you can be assured that we have read the statement and we've considered it. But let me not stop here.
Indeed, Chair. Just to summarize, Chair, what those I represent, or my clients, Chair, and what the statement at the end of the day that I read of Ms. Nungu say, Chair, they say they participate at the commission because they seek to know the truth. Now, Chair, they say they seek to know the truth for 3 reasons, Chair, and I've read them. I'll summarize them as this, Chair. First reason, Chair, is that they hope that this commission will bring them some sort of measure of healing. It will bring them some closure and restoration. That's reason number 1. They also want to know the truth, Chair, because they want to safeguard their rights in relation to the possible future civil claims that they might have against South African police or anyone else for that matter, Chair. And thirdly, Chair, the reason why they want to know the truth is to see, at least it's in hope to see those who are responsible for the killing of their loved ones being brought to justice. Now, Chair, the last 2 points, we submit, Chair, that I'm sure they can be achieved one way or the other. But the first point, Chair, which is that they are hoping to get some measure of healing, closure, and restoration, Chair. There can be no other way that it can be achieved without fair proceedings, or without at least the commission proceeding in a fair manner, Chair. Chair, I'm instructed to record that, Chair, we, or at least our clients, Chair, they don't want to boycott the commission. No one wants to withdraw or remain withdrawn from the commission, Chair. It hurts the families, Chair, as things stand, that while there is money set aside for them to be at the commission, that they are not participating because of the principal decision that they took. As indicated, Chair, last time, my submission is that, Chair, and my instructions are that, however, it will hurt them more, Chair, for them to sit here and participate in an unfair, or what is seen to be an unfair commission, Chair. Whether the truth is told and how beautiful or ugly the truth is unfair, and those are their sentiments, Chair. And they are asking that at least this commission conduct itself in a fair manner. And what is being asked, Chair, is simply that while we appreciate the Chair's gesture, at least last month, Chair, of standing the matter down a couple of times in order to allow, and the Chair himself, to at least try and find some sort of financial assistance for the minors. All that is being asked now, Chair, out of fairness, is to give them an opportunity, at least at worst, for them to pursue the High Court case with a peace of mind, knowing that they too matter, that they matter to this commission, that the commission can say, let's give them that chance, let's give them that fair chance to pursue their rights at the High Court, whatever the results might be. That's all they're asking for, Chair. And, Chair, what we are submitting, Chair, is that it can be, Chair, that your gesture, Chair, of formally postponing the proceedings, no matter the length, Chair, whether a week or 2 weeks, but formally postponing it might send the correct message out there to say the chairperson too is fair and sees this matter, as much as his hands are bound, but he can do something about it, as temporary as it is, but it might send a message, and it might be a message that is finally heeded to, Chair. Chair, lastly, what I need to record, Chair, is that the statement of Ms. Nungu, Chair, as it was read, and all the factual allegations that were put there as to why the commission cannot proceed without the minors, or at least according to the families, why they need the participation of the minors. We need to record that, Chair, out of all the papers that were filed this week, none of those papers challenge those factual allegations that were put forward, Chair. Just to make an example, the issue around Mr. Noki, the issue around Mr. X, which we submit that only the minors can really come and put a different version against Mr. X. We wish to record that, Chair, those, Chair, remain unchallenged, and we wish for the Chair to take those into account when the Chair is making, and the commissioners essentially making their ruling in terms of this application. I thank you, Chair.
You want to ask? You want to ask?
Chair, I'm just what obviously, Chair, what affected what will probably affect also, Chair, whether I can reply or not after the opposing parties, Chair.
But we've made half an hour available for reply to be divided up between you and Mr. Mpofu. If you persuade him to give you 25 minutes and you give him 5, that's fine. Alternatively, you can make any other division of the time you wish.
Indeed, Chair, but Chair, the question really is, Chair, on the point in letting the raise, Chair, it might well be that I don't need to, if that point is dealt with there, I just want to find the Chair's ruling in that regard, if there's any ruling as yet, Chair.
Yeah, I'm going to call on Mr. Oosthuizen now to deal with that point alone, and then I'll give you and Mr. Mpofu a short time to reply if you wish.
Indeed, Chair, and we record that obviously we do support the allegation.
Mr. Oosthuizen, I'd like to hear you now just on the preliminary point, to whether your client should be entitled to appear here and to argue against the postponement. I'll hear you on that only, at this point, and then I'll ask Mr. Mpofu and Mr. Mosiliki. Is that right? Mosikili. I'm sorry, Mr. Mosikili, I got it wrong with this. Give Mr. Mpofu and Mr. Mosikili the chance to reply, and thereafter we will proceed. Once you've given a ruling on that point, and you may be excused at that point, or alternatively you may stay, depending on the ruling we give.
As it pleases the Chairman. Mr. Chair, Commissioner, briefly in 3 points. First of all, the factual basis for our standing here is contained in paragraph 3 of the affidavit that is before you. That demonstrates the financial, political, legal and administrative responsibility of the department in this commission and in its proceedings, and that in itself justifies our participation. I'm not going to elaborate on that, it has already been done in the affidavit. The second point that I wish to make is, you've heard submissions here today, and the issue of prospects of success in the High Court is a very relevant consideration for you. The legal team that is here is the legal team that is appearing for the President and the Minister in the High Court, and we are perfectly situated to assist you as the Commission with any issues or information that you require as far as prospect of success is concerned. Some of those issues have now been raised here from the bar by Mr. Mpofu. There were a number of allegations made, but we are in a position to assist you with that. Then the last point that I want to make, and that I want to make very clear, is that the department is not here today because it wants to dictate or intimidate or bully anyone. We are here...
If you tried, you wouldn't get very far.
Well, even if we tried, but I want to make it clear...
Take it you wouldn't dare.
No, I wouldn't, Mr. Chair, but the point is Mr. Mpofu accused us of acting inappropriately, of doing something that should not be done. I take umbrage to that. That is not the motive of the department. That is not why they're here. They are acting as a responsible department of state, aware of their constitutional duties and their obligations. And on this third point, we fully respect the rule of law and the principles that are applicable to this commission. You are the master of your own procedure. I cannot demand as of right to address you on behalf of the department. You determine your own procedure, and procedure includes issues of standing. I have shown our interest, I have shown how we can assist you, and we are asking you, under your procedure, to allow us to help and assist you on a matter that is of importance. This postponement is not simply some formal and procedural issue to get out of the way. It has important repercussions. And that is why we are here today, to look after the public interest, the interest of the state. And we do it on those three bases. One, the factual basis concerning finances and administration set out in the affidavit. Two, the position that we are in to assist you. And three, the respect that we have for you as the master of your own procedure. That is our...
Well, the third point wouldn't give you locus standi, would it?
No,
but the third point doesn't give you locus standi. The
yes,
third point, the point you make really in response to the suggestion made by the other side, that it's improper and inappropriate and ill-advised and intimidatory and so forth for you to be here.
No, but Mr. Chair, the point that I'm trying to make is not that I am claiming locus standi as a matter of right. This commission is in control of its own procedure, and in view of that power that is in the hands of the commission, I cannot claim to be entitled to address you. I must get an indulgence from you, and you are empowered to grant me that indulgence on the basis of Regulation 19 of the Commission regulations and on the basis of the provisions of the Commission Act itself. And the basis for that request are the first 2 points that I've made. The factual basis in paragraph 3 and the fact that we are in a position to assist you. Thank you, Mr. Chair.
Any reply, Mr. Mpofu and Mr. Mosikili?
Yeah, thank you, Chairperson. Very briefly, the issue really is that and I want to read this. I just will give you the heading, Chairperson. It's 178 of LOSA that I refer to, which says the President must appoint a commission of inquiry, him or herself. And it's the writing that deals with passing the buck and abdication of that power and so on, and the fact that it has to be done personally by the President. So I'll just refer you to that. As far as this new approach is concerned now, I'm puzzled. There's no. It can't be that my learned friend says he's now asking for an indulgence. If he was asking for an indulgence, he would have done so in the papers. He wouldn't have waited for us to raise the objection. He's not asking for any indulgence. Actually, in his document, he says that he's entitled to participate. And then the whole thing would have been different.
If he's wrong on that, then...
Well, if he's wrong
on that, then it's sensible of him to apply.
Well,
you apply...
That's a different matter.
He can apply from the bar as well for an indulgence if he needs it.
Well, Chairperson, please, with the respect, all I'm saying is that...
I'm putting a point to you so you can answer it.
Yes, no.
Point, you show me why.
Well, I'm showing you that it is not true. It cannot be that they came here to ask for an indulgence. If he's saying because I've objected, he's asking for an indulgence, that's a different matter. But you know, Chairperson, what I'm saying is that when they came here and did this, they assumed, which is exactly what he says he didn't do, assumed that they have such a power. If he had asked for an indulgence, the process would have been different. He would have asked for the indulgence. I would have been answering. He would be replying. The only reason that I spoke first and he's answering and I'm replying is because he asked for no such indulgence. I'm not saying he cannot ask for it now. I'm just saying that that is not what is happening here.
Joe, it is you get 2 bites at the cherry, otherwise you would only had 1.
Oh, yes, well, I'm happy. I'm grateful for that, but let's call a spade a spade. The issues of if indeed the Commission is a master of its own procedure, that must necessarily include the question of granting or not granting a postponement. That is an indulgence, as my learned friend correctly puts it, which is squarely in the hands of the Commission. There is no place in the exercise of that indulgence for the people who appointed the Commission in the first place, so that it may exercise those powers to themselves.
I don't understand. The department didn't appoint us. The president appointed us.
Well, it's played a role. According to these papers, they say they play.
The president appointed us.
Yeah.
The appointment was by him.
Yes, but. Yeah, so sorry, Chairperson.
The department plays an administrative role. They provide logistical support and they provide the funds. That's their role, as I understand it. And if they try to do anything else, we'll tell them where to go and get off.
No, that's not what they say. That might be what you say, Chairperson. They say at 3.4, in addition to its political and constitutional duty to the department, whatever, to assist and support the President of the Republic of South Africa in the exercise of his constitutional powers and functions under Section 84(1) of the Constitution. So the powers of the President under Section 84(1) of the Constitution are the powers he exercised to appoint you, Chairperson. So if they assisted, they might not have been the principals, but if they assisted in such an exercise, then they played a role. In any event, the point I'm making is this. The people who appointed the Commission or assisted, whatever, have no place in directly, that's where the emphasis is, in directly participating in these proceedings to influence that exercise which they themselves had delegated to yourselves. That is re-usurping the very powers that had been delegated, which should have been delegated fully to assure the independence of the Commission. It's a matter of principle. It's wrong. I don't think it's ever been done in this country or any other country, but that's why we object that it should not be allowed to be done now. Sorry.
Is that what you have to say, Mr. Mpofu?
That's all.
And now, Mr. Mosekile.
On the point.
Yes, answer. Now, Mr. Mosekile, is there anything you want to add? I got it right this time.
I thank you, Chair. Chair, all you have to say this, Chair, is that, Chair, it will seem very, very bad, Chair, for this Commission that someone, Chair, who at least seems to be outside the terms of reference, Chair, comes here and asks for a postponement not to be granted. Chair, we had a situation where there was a lady who was killed just a few days after the commencement of the Commission, Ms. Masutle, and really we had to fight to get her to be part of the Commission because she was an outsider. But then, Chair, for someone who we think died within that ambit of the terms of reference did not get included, Chair, but then to have the opposition coming from the direction coming from, Chair, it just simply does not look good and does not seem to be correct, Chair, and will desist, Chair, any suggestion that they have a right to at least oppose any postponement, Chair.
Thank you. We'll take a short adjournment or a long adjournment, depending how long we require, and we'll come back as soon as we're in a position to announce our ruling on this point. we've come to the conclusion that the Commission resumes. We've come to the conclusion that the Department should be allowed to intervene in these proceedings in order to oppose the application for postponement. The reasons which have induced us to come to this conclusion will be set out in our ruling when we deal with the merits of the matter. The first speaker who I've been asked to call upon to deal with, first respondent who I've been asked to call upon in relation to the response by the respondents is the Counsel for London, Mr. Berger.
Chair, thank you. We abide the decision by the Commission. I just want to put two things right, which I think the Commission understands. In his opening, Mr. Mpofu referred again to the toxic relationship between my client and the police. Well, that's not the version of his clients that we have. That's not the evidence before the Commission. And, Chair, you are aware that there's a debate out there. We'll address that at the end of the day. But we shouldn't be seen to accept that statement as being non-challenged coming from Mr. Mpofu. Secondly, he referred to his notice of motion and the annexure in the High Court as to the number of counsel employed by Lonman. That's also factually wrong. Lonman has for phase 1 had 3. We were whittled down to 2. You know, for the past month or 2 we were 1. Today we 2 again. Monday will be 1 again. But we don't employ 5 people. What the relevance of that is beyond my comprehension. But I just don't want to allow perceptions or political stances to go into the world which are factually incorrect, even if they're irrelevant to the process. But for those 2 corrections, we abide your decision, sir.
Yeah, thank you, Mr. Berger. Mr. Oosthuizen, I'm told that the respondents have agreed among themselves that you are to be the second speaker. Yes. On behalf of as part of the response to the application.
That's right. Thank you, Mr. Chair, Commissioners. I want to address you on 3 levels. Level 1 is an introductory remark where I wish to make 3 points. Then in level 2, I will address you on the merits where I wanted to make 4 points, but the issue of standing has now been resolved, so then I'm going to address you only on 3 further points. And then in the last level of phase, I will deal with some of the matters that Mr. Mpofu has raised in response to what he said. As far as the first level...
Have you got heads
yes.
to give us? And to make available to your learned friends as well?
Not yet. I will ask them to be made available now. Can you just give this?
I see they're skeletal heads, they're only 8 pages.
Yes, that's right. But I'm not going to follow them. They are there just as a precaution. In view of the way in which the debate has developed, I'm going to address you orally. May I start, first of all, by way of introduction to make 3 points. First of all, the evidence and the factual matter that we rely upon is before you. There was no replying affidavit to that, so it stands uncontested. I'm not going to repeat it. It is on record before you. Secondly, for the first hour and a half this morning, I did not hear any argument on postponement. I heard an attack or a critique of the department, and I heard a re-argument of what is pending before the High Court. And the third point that I then want to make by way of introduction is that coming to an issue of postponement...
I don't think that's right. I mean, he did say, his argument was, it's important that his clients should participate in the proceedings. If they don't participate in the proceedings, it's unfair. The proceedings will be unfair. Therefore, the proceedings should be postponed until an order is obtained in the High Court, or alternatively, until they've got private funding, whichever comes earlier. That was the argument. Admittedly,
Yes.
It wasn't put as perhaps as crisply as that, but that was essentially the thrust of the argument put up. So it's not fair to say that there was no argument in support of it.
Mr. Chair, if that was the argument, then the rationale for the postponement is to obtain funding so that they can return. And then one would have expected that there would have been an address to you on the prospects of funding.
No, that's not right. I'm sorry to interrupt you again. The argument is there must be a postponement to prevent an unfairness which would result from the fact that they haven't got funding and they can't participate. I mean, whether it's a good argument is not another matter, but that was the argument put up.
Well, I will then deal with it on that basis. Now, we've already made the point in the affidavit, and my learned friend and I in agreement thereon, that basically the request for a postponement is an indulgence, and it is therefore incumbent upon Mr. Mpofu to put those facts and arguments before you that would convince you in favor of such a postponement. May I then go to the merits of this matter? This matter turns basically on the prospects of obtaining funding. Now, as far as private funding is concerned, I see that one of the other parties have filed an affidavit in which they describe this as a pipe dream. We know that for a few months now, there's been an attempt to get private funding. None of that has really been successful. There was past funding, but it stopped from the private sector. And since then, there hasn't been any funding forthcoming from the private sector. Now, we are told about attempts that are going on. But with all due respect, Mr. Chair, the detail that is given is so vague and so sweeping that one cannot evaluate what the prospects of success with regard to such funding are. As far as getting funding...
I'm sorry, do they have to... So you're talking about the prospect of private funding?
Yes.
Do they have to go that far? What they're saying is the terminus ad quem, as it were, of the relief they seek is the outcome of the proceedings in the High Court. They say if before that we get funding from a private source, then we'll be back in any event. So that's just put in by way of a qualification to meet an argument that even if before the proceedings in the High Court are over, they've got funding, well then they should be back anyway on their own basis. So the real issue is they say we want a postponement until the outcome of the proceedings in the High Court. They don't ask for any relief after that. Their claim is limited to relief up to the outcome proceedings in the High Court, and they say if something happened before that, well obviously it'll fall away. But so the prospects of success of getting private funding with respect to are irrelevant, sorry, on that approach.
Well,
but I don't interrupt you, but I don't think the submission you put to us is entirely correct.
Mr. Chair, they put it in the alternative. They will come back either if they have private funding or upon judgment being given in the matter in the High Court. And because they put it in the alternative, I must deal with both legs. I can't leave the alternative leg out of the picture. And that is why I made my submission on the private funding, to cover that conditional qualification that they add to their argument. As far as the judgment itself is concerned, there was a notice of amendment delivered late yesterday afternoon. Mr. Mpofu has already given you the brunt thereof. But he then told you that the relief that is now being pursued has been canvassed in the papers. They have not. And you don't have to take my word for it. You can look at paragraph 16 of the judgment of the Constitutional Court. In the last paragraph, or in paragraph 16, in the middle, a consideration that comes into play is that it is the object of the Legal Aid Act to render or make available legal aid to indigent persons and to provide legal representation at state expense as contemplated on the Constitution. Its provisions have not been challenged as constitutionally invalid, nor has the refusal by Legal Aid South Africa to grant the applicants legal aid been challenged on review.
Presumably it was those two sentences which were the precipitating factor for the application for an amendment.
Yes, but the point is that that has not been canvassed on the papers. This now turns into a review application. Whether or not the review was launched in time, according to Paja, has not been canvassed on the papers. Whether the Legal Aid Act in itself is unconstitutional has not been canvassed on the papers. The main relief that was pursued on the papers was a final interdict ordering legal representation at state expense. And the papers were dealt with and the issues were canvassed on the basis of that analysis, the tried three requirements of an interdict. I already have instructions to oppose the application for an amendment, and I don't have a crystal ball, but in all probabilities that will cause the matter to be postponed and not finalized on the 20, or even be heard on the 25th and the 26th of September. Now, Mr. Chair, what concerns the department is this. The injured and arrested miners are prepared to come back to this hearing and continue upon judgment in the High Court, even if it goes against them. Now, if that is their attitude, why do they have to wait a month?
I'm not sure they say that. All they say is they ask for a postponement until judgment in the High Court. Their papers, one can call the transcript of what was said, describe those papers. The papers appear to be silent on what will happen if they lose in the High Court. Or is there something I've overlooked?
On page 133, at line 10. Thank you, Mr. Chairperson. Yes, that is a fair question. No, it does not. As I indicated, maybe not clearly, we're talking about the outcome in the first instance. In other words, we would assume to ourselves a duty to come back at that stage of the outcome of the first instance.
Sorry, what
line 10.
Mr. Oosthuizen, that's in response to the question that was raised as to the time frame for which the adjournment was sought, whether it would be at the end of the High Court case or whether any one party would take that on appeal. That was the question in response to which Mr. Mpofu said that.
Yes, and as I understand the transcript, if there is an appeal, they will not let that deter them. Whatever be the outcome of the court, or quote, the High Court, upon that judgment, they will assume the duty to come back at that stage at the outcome of the first instance. They don't say favourable outcome, they don't say adverse outcome, they say once there's an outcome, we will come back.
Chairperson, I'm sorry, I don't want to interrupt my learned colleague, but just to... But I will, yes. Commissioner Hembraj is quite correct. I just don't want my learned colleague to go on a wild tangent. The question was whether the word outcome encompassed appeals, which it sometimes does. And I just made it clear that we would have a duty, as council at least, to come back. The question I suppose you could ask is come back and do what? It would depend on the outcome. We would come back, certainly, if we were successful, we'd obviously come back and participate. If we are unsuccessful, we would come back and either ask for a postponement or say we're not going to be here or we're withdrawing permanently. I can't say what would happen. It will depend on the instructions. But the only thing that is clear is that if the application is successful, we would come back to participate. But that was the context.
Yes,
it was not...
Mr. Oosthuizen, it does seem to be clear. They're not saying that they'll come back even and participate in the proceedings thereafter if they lose in the High Court. They may take the decision in the High Court further, of course, but they accept that the relief they seek only will come to an end if granted once the High Court has given its decision. That's the thrust of the passage. Well, and it was, I understand why you said what you said, but it was ambiguous, but I think the ambiguity is now being cleared up by what Mr. Mpofu said.
I'll accept that, but just to explain, that was our concern when we read what was said in the transcript. And also, the fact is that they have already withdrawn from these proceedings, albeit provisionally, and for the past 6 weeks, the Commission was able to continue. So the fears that are expressed and the statements that are made that you won't be able to do without us is simply unfounded. Now, as far as the judgment in the High Court is concerned, the issue of the prospects of success therein is important. My learned friend has indicated that they rely on Section 34 and Section 39. Now, the Constitutional Court has already given indication of its view as far as that is concerned. If I can take you to paragraph 14 of that judgment. There, the Constitutional Court says the following. Section 34 deals with disputes that can be resolved by the application of law. The Commission's findings are not necessarily to be equated to a resolution of a legal dispute by a court of law. That is already a firm indication that the case as based on Section 34 is simply, with respect, misconceived. Then there is the reliance by my learned friend on paragraph 15. Now, in paragraph 15, there's a long discussion, and ultimately, the...
I'm sorry, Doctor. Paragraph 14, I'm not sure. Go ahead. I'm not sure paragraph 14 goes as far as you would suggest to us it goes, because it uses the word necessarily. The Commission's findings are not necessarily to be equated, which means the Constitutional Court is leaving the point open, as I read that paragraph. But anyway.
Well, with respect,
I must put that point.
Yeah, no, true. I mean, I read out the paragraph in the words that it has been reported, and with respect, this must be read against the natural inclination of any court on appeal that does not want to preempt whatever is going to be decided by the High Court. But this is already, in my respectful submission, a strong indication of how the Constitutional Court view the matter. In paragraph 15, the Constitutional Court deals with an issue of fairness, and they approach this from a moral analysis, and they conclude to say, absent a fair opportunity, the search for the truth and the purpose of the Commission may be compromised. But then comes paragraph 16, which must be read together with this. This means that unfairness may arise when adequate legal representation is not afforded. But this does not mean that courts have the power to order the executive branch of government on how to deploy state resources. And when the desirable objectivity of equality of arms before a commission translates into a legal right to representation that must be provided at state expense, it is a contestable issue. The consideration that comes into play is that it is the object of the Legal Aid Act to render or make available legal aid to indigent persons and to provide legal representation at state expense as contemplated in the Constitution. The point being this, on both the legs that my learned friend showed you, the case for the applicants is relying. There's been an indication already by the Constitutional Court that they are not so sure that those legs are very firm. And on that basis, I respectfully submit that there is no real prospects of success with the judgment in the High Court, excepting that it proceeds on the 25th and the 26th of September despite the logistical problems. That brings me then to the public interest issue. We've dealt with that in paragraph 5 of our affidavit. I am not going to repeat the factual allegations that were made therein. My learned friend at no stage countered the argument or the submissions that were made in that paragraph. And I didn't hear one single submission from him to say that those considerations of public interest are irrelevant or should not be taken into consideration.
They're not traversed on the papers. There's no affidavit filed in response denying those allegations.
But there was also
So
no
we have to
argument.
take the allegations, insofar as they're based on fact,
Yes.
as being a correct statement of the facts.
Correct.
I understand sometimes an affidavit contains arguments. Presumably the fact that those aren't traversed by another affidavit doesn't mean the argument is accepted. The rules apply in relation to disputes of fact, not disputes of argument.
No.
But insofar as they're factual averments, they're not traversed.
I accept that. But in this case, when this procedure was followed, Mr. Mpofu on at least 3 or 4 occasions indicated that he realizes he's now busy with legal argument, but that would ordinarily have also been stated or advanced in the affidavit, and he was then allowed to proceed. We returned the favor. Our paragraph 5 contains a lot of factual allegations, but there are also conclusions, inferences, and submissions made. And what I'm saying is that none of those submissions have been countered or made of as irrelevant or playing no role at all as far as the postponement is concerned. So the international reputation of the country is important, and delay will compromise that. The ability of the government to put preventative measures in place to prevent a reoccurrence of the Marikana is being compromised the longer it takes for this commission to finish its inquiry and make its recommendations. So, looked at it from that perspective, there are very good and pressing reasons for the Commission to continue, whilst there are, with all due respect to my learned colleague, no good reason why there should be a postponement. Mr. Chair, allow me then to deal with a few of the submissions that Mr. Mpofu made. Now, unfortunately, you will have to bear with me. Some issues I've already addressed, I just want to eliminate them, and I just want to select those that I really want to address you on. So just bear with me for a moment. As far as the submission was made, or as far as there was an attempt to suggest that the evidence leaders is on the payroll of the department, Regulation 5 and Regulation 6 of your Commission regulations address that fully. The evidence leaders are, in terms of Regulation 5, in fact, designated by the chairperson. They're not even appointed by the department. And in terms of Regulation 6, the regulation itself prescribes what fees or travelling allowances are to be paid as the Minister of Justice, with the concurrence of the Minister of Finance, determined. So it's not really a case of he who pays the piper calls the tune, and the suggestion is deplorable.
There's no reason to think that if he tried to call the tune that anyone would listen to.
No, but, Mr. Chair, that is the reality. But we have a platform here where the media is present. And these type of missives are sent into the wide world, and it is repeated by people who doesn't have the insight that you have. And it is misunderstood and a false perception is created. I realize that in reality, if this was a closed session, I wouldn't even have to address you thereon. But I have to look after the interest of my client and the interest of the Commission. And any attempt to create that kind of an impression must immediately be nubbed. in die kiem gesmoor word? Nipped in the bud. That is what happens when you ask an Afrikaner to speak English, Mr. Chair.
In the bud, right. Well, we can also nip it in the bud by my saying now, as forcibly as I can, that any attempt by anyone to interfere with this Commission's functioning as an independent body will be vigorously resisted and publicly exposed. And there can be no prospect at all, as far as we're concerned, of anything of that kind happening. If anyone were to try it, there would be very serious consequences. Okay. And I must also say that there has been no attempt at all of any kind to do that. And if there had been such an attempt, what I've said would happen in the future, if it were to be tried, would already have taken place. So the public can have the assurance from us as commissioners that nothing of that kind has happened, and if anything of that kind does happen, there will be very serious public consequences.
Okay. May I then go to the number of witnesses? Mr. Mpofu said, well, if you still have 28 to go, you're not going to finish in any event. But surely we must make the most of the time that is available. We can't just throw in the towel and say, well, if that's the case, then we stop work today because we're not going to finish in any event. So the number of witnesses, the work that you have to do, the importance of the task resting upon your shoulders, all of that dictate that we go on rather than stop. Now, Mr. Mpofu said that we need closure in this. Our argument on this is on the paper. We say, yeah, closure is a good thing, but that does not mean that that is necessarily part of the mandate of this Commission. The Commission's mandate is defined in its appointment. And if it achieves closure, well, that's a good thing. Now, Mr. Mpofu's argument is that without them participating, and in their absence, there will not be any effective outcome. Now, with all due respect, why will it not be effective? That is speculation. He also makes the point that the Commission's report and recommendations and referral will lack credibility. Why? Because 350 minors and arrested persons are not happy with it. What happens if the President accepts it, if the Department accepts it, if Parliament accepts it, and if the governing political party accepts it, and if the general public accepts it? Why is it that if things don't go the way of 350 injured and affected or arrested minors, then all of a sudden nothing will be effective and nothing will have credibility? That is, first of all, not a logical argument. Secondly, it is not based on any facts, and it is pure speculation. It's hyperbole. There is no basis for that, Mr. Chair. Now,
I think, to be fair, Mr. Mosekile put it in a slightly different basis.
Yeah.
He said, even if, I think I'm being fair to him, even if the results are right, even if the truth has come out, if the process was seen to be unfair, that would somehow affect its acceptability and legitimacy and credibility, I think, to use words he used. That was his submission. So you're not, with respect, correctly summarizing the submission put up.
Now, I will deal with that submission at the end when I come with this, but at the moment I'm dealing with Mr. Mpofu's submissions. Now, Mr. Mpofu said that we make the point that a postponement will not infringe their rights. Now, the point that we made in our paragraph 6.4.2 is that it won't infringe upon their procedural rights. And that is their procedural rights here in this Commission. He referred you to LAWSA, and he referred you specifically to paragraph 169. our submission in our original papers did not go so far to say that there will no infringement be of any rights. This postponement raises a procedural issue. And we are saying that there is no procedural right of theirs that will be infringed. Now, my learned friend then went on to say that there's a lot of misrepresentations, and he highlighted some of them. In general, I again want to draw your attention thereto that there was no replying affidavit. He then made one point. He referred you to Annexure M2, and he analyzed the public statement on behalf of the department, line by line. And in the course thereof, he said, but there are other commissions where the Legal Aid Board paid for legal representation. And he then referred to a case in the Land Claims Court. Now, this is something that has been canvassed on the papers in the High Court. As far as the restitution of land rights in land of 1994 is concerned, Section 29 of that statute allows representation at state expense. There's a legislative mandate for that. As far as the Truth and Reconciliation Commission is concerned, in Section 34 of the Act that created it, there was a specific mandate, legislative mandate, given for legal aid representation. But when we deal with the so-called Royal Commissions of Inquiry, that was always appointed under prerogative of the Crown, and that is now codified in Section 84(1)(f) of our Constitution. When you look at that type of a Commission of Inquiry, there is not a single reported case of instance where there was a legislative provision that allowed representation therein at state expense. What we have here, as far as the Legal Aid Board is concerned, is the following, and that is where the legal aid to some of the parties before this commission comes from. The Legal Aid Board's position on the papers and on record is the following. As a general rule, our statute does not allow us to fund legal representation at commissions. But our Act, our Empowering Act, prescribes a legal aid guide. And that legal aid guide, in terms of Section 12, if I remember correctly, is clothed with the force of law. It is basically recognized as a form of subordinate legislation. And in that legal aid guide, there is provision made for an exception that under special and exceptional circumstances, there is a reserved discretionary power to be exercised by the CEO of the Legal Aid Board. And it was in the exercise of that exceptional power that some legal aid was afforded at commission proceedings. But as a general rule, we don't do that. That is the background. Now, it is against that background where, and on matters that has already been canvassed on the papers, that Mr. Mpofu now criticizes the Legal Aid Board, and he says that their explanation and the statement is contrived and it is wrong. But he doesn't give you the background. He doesn't explain to you the legal structure in which this decision was taken. And I have to rectify that. Then Mr. Mpofu deals with the issue of fairness. Is whatever is unfair in one context is also unfair in another context. May I take you to paragraph 13 of the Constitutional Court judgment. And I quote, "The applicant sought further succor for their claim for state-funded legal representation by alleging infringement of Section 34, access to court, and Section 9, equality of the Constitution, and by relying on general considerations of fairness It suffices for the limited purposes referred to above to state that none of these arguments warrants our intervention in the order granted by Rolingwa. And Rolingwa dealt with fairness not in a general context, but in a specific context. Now, Mr. Mpofu also used the alarmist argument that we mustn't take a short-term view, because if we do, we run the risk of having another massacre like the one that was experienced. Now, if this commission doesn't finish its job, it will be ongoing. The whole purpose of the commission is to investigate and to prevent reoccurrence. So we can't take a long-term view. There is a certain measure of urgency in this investigation. Not that we must compromise the Constitution or the search for truth, but we cannot ignore the urgency of and the importance of this investigation. Now, to come back again, Mr. Mpofu made the point to say that the appeal to the Constitutional Court was only with regard to the interim relief. Now, in paragraph 8 of his heads of argument in the North Gauteng High Court, he made a point, and the point that he made was this: in order to decide part A of the notice of motion, which deals with interim relief, it will be necessary to consider and decide on certain aspects of part B of the notice of motion, which is concerned with the right to legal representation at state expense. And that is also dealt with in so many words in the judgment of Rolingwa. And if you analyze that judgment, you'll find that one of the grounds upon which the interim relief was dismissed is that they haven't made out the case for a right to legal representation at state expense. It was at all times common cause that the parties and the witnesses before the commission have a right to legal representation. The bone of contention was whether such legal representation had to be given at state expense or not. That is what the whole case is all about. Now, when you draw a distinction between a between a final interdict and an interim interdict, as I understand it, Mr. Chair, the situation is as follows.
I'm sorry, Mr. Winston, I don't understand that. It may be that Mr. Mpofu was perhaps ill-advised enough to make that submission in the High Court. And it may be that Judge Rulinga took a similar approach. But one cannot ignore what's said in paragraph 11 of the Constitutional Court judgment, where they say, our consideration of the High Court's finding must not, however, be seen as anticipating the outcome of the main review application and the final relief sought there. That's what the Constitutional Court said. So therefore, whatever Mr. Mpofu wisely or unwisely said in his heads in the High Court, that can't detract from what the Constitutional Court said in the sentence that I've read.
Mr. Chair, yes, perhaps I've been a bit undiplomatic.
I think you over-egged the pudding there.
Yeah. I'm a bit undiplomatic in my submission, but the point that I'm trying to make is that as far as prospects of success are concerned, we have the following situation. There's an interim interdict called for and there's a final interdict called for. Whether you've got a right is a matter of law. Whether that right has been prima facie or finally clearly established is a matter of evidence. Now, all the evidence is in, and it has been in also when Part A has been decided and also when this matter went to the Constitutional Court. So whether or not that right has been established on a prima facie basis or on a clear basis, that is no longer the debate. It has been the debate all along of whether they've got a right to that legal representation at state expense. And that is then where paragraph 12 of that same judgment comes in. And the Constitutional Court points this out. They say there are only 3 provisions in the Bill of Rights that explicitly entitle someone to claim legal representation at state expense. Then the Constitutional Court deal with each one of them, and on page 8, third line from the bottom, they say, these do not apply here. The applicants are neither children nor detained persons, and the proceedings that are the subject matter of this application, namely the commission proceedings, are not a civil or criminal trial. So it is on that basis that I address you to show you that the prospects of success is not wara 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 as Mr. Mpofu wishes you to believe. Now, Mr.
I'm afraid I've never seen those words "wara wara" in the dictionary. What do they mean?
I'm afraid I also don't understand.
It's a term of art used at the Pretoria bar. I'm afraid I've never come across it before, but perhaps you could explain it to me now.
Mr. Chair, Mr. Mosekile then raises an argument which is fundamentally based on a golden rule, that justice must not only be done, it must be seen to be done. And his argument is basically that this whole process, also the process before this commission, must be seen to be fair. But fairness is a two-edged sword. I may personally, within the context of my own value system and my own morals, view something as fair or unfair. But when we talk about fairness in the context where we are today, and where you are called upon to exercise a value judgment on what is fair or not, you are called upon to exercise that value judgment not only by taking into consideration the interests and the expectations of the injured and affected minors. There are other parties before this commission who also has an interest that this matter proceed. You have the Department of Justice and Constitutional Development who come here as guardians of the public interest and impress to you that it is in the interest of the country that this matter proceeds. So it isn't so simple as to say, well, the procedure must be fair to a selected and identified and circumscribed group of individuals. It must be fair to everybody. And if we look at the broader picture, if we look at the concerns raised by the department, if you look at the importance of this matter, then fairness also requires us to proceed. The unfairness that they are complaining of is not an unfairness in these proceedings. It is the unfairness that in their perception is created by the fact that they don't have state-funded legal representation. And that is something beyond your control. That is something which, with all due respect, you can take note of, but it cannot inform your decision. And under those circumstances, I would respectfully submit that on the one hand, no proper case has been made out for a postponement, and on the other hand, there are pressing considerations of logistics and of public importance and of public interest that requires this commission to proceed where possible. If there's anything else that I can assist you on, I will gladly do so. If there's anything that you want me to answer, I am available. Those are my submissions.
Thank you, Mr. Hussain. Mr. Matabedi, I think you're the next person who is prepared, as I understand it, to address us on behalf of the respondents, in your case being the SAPS.
That's correct, Mr. Chairman. Mr. Chairman, we have prepared heads of argument, which I'm going to ask my instructing attorney to circulate them. Thanks, Mr. Chairman.
Everybody who would like a set of the heads as entitled thereto got one. Has the Human Rights Commission been given a copy?
Chairperson, on behalf of the Manane family, we haven't received a copy.
Yes, no, you must.
Thank you.
Everybody apparently now got a set of, who wants a copy and entitled to a copy got one. They now proceed, Mr. Mutbegi.
Thanks, Mr. Chairman. Mr. Chairman, I've been given strict instructions by my attorney to be court and bondage. That being the case, Mr. Chairman.
For the benefit of those who don't understand Afrikaans, we should get the interpreter to interpret that expression. Unless you can do so for us. Short and to the point.
Thanks, Mr. Chairman. Mr. Chairman, that being the case, I don't intend to traverse aspects that have been traversed by my colleague. I'm also not going to go through my heads of argument or the opposing affidavit prepared on behalf of SABC. Mr. Chairman, the first aspect that I would like to deal with is the issue of perception. And I think dealing with this, Mr. Mpofu is very helpful in giving us an answer on this aspect. Because as set out in the record, page 13121, yes, that's day 29, starting at paragraph 12. Sorry, the 29th of August, 2013. Day 126. From line 12, the following appears. Mr. Mpofu, thank you, Chairperson. And it's simply to say, Chairperson, that at least the perception of the people that we represent is that everyone has turned their backs on them, starting from the employer, the police, some government officials or ministers. There are BEE partners and all sorts of people, but they do have confidence in this commission, as I've already indicated before, and we hope that the commission will not find itself joining that illustrious list, and we know that if they feel like that, we will be the first ones to point out that about the difficulty of the task that you have in balancing the interest of everyone. So I just wanted to assure you, Chairperson, that we will, as we've always done, ensure that whatever the outcome of the application, this is not relevant going forward. But the point that we are making, Mr. Chairman, is because of what is said out herein, then the perception that is, it's being argued that there is a perception on the part of the applicants regarding the proceedings in the commission. We respectfully submit that because of what has been said by the council, such is unfounded. And that also now ties into the integrity of the evidence leaders. We respectfully submit, my Lord, that this also is an indication that the integrity of the evidence leaders is solid. It's not being questioned. And the reason why evidence leaders have been appointed is to assist the Commission in finding out the truth as to what happened during the relevant period. Now, that being the case, Mr. Chairman, we respectfully submit that there is no reason why, if the applicants are in possession of any information or evidence, why that evidence can't be made available to the evidence leaders with the undertaking that if need be, they will come and testify as witnesses. There's nothing that precludes them. So our submission is that that perception is self-created. And when it comes to the families of the deceased persons, it's just unfortunately, Mr. Chairman, my view is that that perception of unfairness or prejudice is self-created. For the simple reason that the Department of Justice has made funds available to them so that they can be accommodated, they can pay their legal representatives of choice. So there is no reason why they can take part in the proceedings. Or alternatively, there is no reason why the applicants can make available any information or evidence available to the legal representatives of the families so that they should cater for their interest, because it appears they have got no problem with it. Now, with regard to the aspect of unfairness referred to by my learned friend as set out in the judgment of the Constitutional Court at paragraph 15, the last line, which reads as follows: absent a fair opportunity, the search for the truth and the purpose of the Commission may be compromised. Now, we respectfully submit, Mr. Chairman, that that opportunity is not absent. It has been made available to them. The evidence leaders are there to cater for their interest. They decided not to take part in the proceedings of the Commission. No one is stopping them. Now, the other aspect...
Are you saying that if the evidence leaders say, we're prepared to listen to you, we'd like to hear what you have to say, we will convey your version to the Commission, and we will call you to give evidence in support of what we've conveyed in that regard. So that will constitute a fair opportunity in the meaning of that expression as used by the CC in the last sentence of that paragraph.
That's my submission, and that has already been demonstrated that versions of some of the applicants who made statements which were submitted to the Commission have been put to General Mpembe. The search for the truth and the purpose of the Commission may be compromised. That's correct, Mr. Chairman. The search for the truth and the purpose of the Commission may be compromised. At this stage, there is no evidence or indication that the proceedings of this Commission are being compromised. And not only that, Mr. Chairman, currently rules have been adopted by this Commission to ensure that the evidence leaders, even in the past, they've done their duties and responsibility to ensure that those who do not wish to take part in the proceedings, if they've made statements available to the Commission, then those versions are being put to witnesses called. Not only that, Mr. Chairman, in the past it has been demonstrated that the evidence leaders have called for documents, have consulted with police witnesses, simply to ensure that all the relevant information and evidence is being placed before the Commission to enable the Commission to come to a just and fair conclusion of its inquiry.
putting it on record, are you, that, which is, I understand to be a fact, that despite the fact that the police witnesses have been led by police counsel, they've previously been interviewed by the evidence leaders who have obtained information from them with a view to ensuring that an accurate picture of what happened is put before the commission. Is that what you're saying?
That's correct, and it continues, and we continuously get requests from, not only from the evidence leaders, even from CALS about information that they require. So we respectfully submit that that takes care of any...
It's the same procedure, of course, is capable of being applied to all other witnesses and indeed other parties other witnesses or other persons who can give evidence which can assist the Commission.
That's correct, Mr. Chairman.
I understand that the evidence leaders also are assisted by investigators, and I understand, it's not a matter of record yet, but I'm putting in record. The investigators also have, I understand, interviewed the police with a view to getting information for the purpose previously mentioned. Is that correct?
That's correct, Mr. Chairman. Not only, investigators, outstanding, investigators. Now, with the aspect of, or the contention that there is a discrepancy between what is said by the deponent who deposed an affidavit for the Department of Justice and the police, we submit that the contention that is being made is that if a postponement is granted, valuable time that could have been fruitfully used in ensuring that the proceedings go forward will be lost. And that is the submission that we are making. And Mr. Chairman, you will have to take into account that at this stage, 2 extensions have already been granted. And the reason for the granting of the extensions was with the hope that during these 2 periods, the Commission would make progress, the Commission will finalize, if not the hearing of evidence, even the making available of its report. Now, with respect to the issue of prejudice, we respectfully submit that neither the applicants nor the families have demonstrated that in the event that the proceedings go forward, they will be prejudiced. We respectfully submit, Mr. Chairman, that the granting of the postponement for the reasons as set out in the opposing affidavit of the South African Police Services, they will suffer serious prejudice, because one of the aspects is that the findings of this commission may play a very important role going forward as to how members of the South African Police Services should conduct themselves, and even probably taking remedial steps. Now, on the aspect that the South African Police Services says, because they are saying they are not prospects of success that demonstrate arrogance, Mr. Chairman, I think that is misplaced for the simple reason that when the affidavit was compiled and prepared, that was based on the case that was to be made. Now, subsequently, an amendment has been, given that changes the initial order that was going to be sought in the High Court, and the answer.
Change the order sought. Actually, changes the order sought in the High Court.
That's correct. That's what we're saying.
The order sought here, but in as much as the order sought in the High Court will be different.
That's correct.
The time span and the time taken to give the judgment may be much longer.
That's our submission. Now, the last aspect, with regard to the criminal cases that have been cited, on which reliance is sought, Mr. Chairman, our view is that in this commission, no competing rights are being adjudicated upon. All people who are being called before this commission are called to testify as witnesses and not as parties. And even if at the end of the day the commission makes a damning or an adverse finding against any person, such kind of person have a right to challenge the findings of the commission. Nothing precludes such a person to launch a review. Those are my submission, Mr. Chairman.
Thank you. Mr. Budlander, I think you're the last person whose name has been given to me as one to address us.
Thank you, Chair, and members of the Commission. Can I say at the outset that the evidence leaders have been asked by Council for the Department of Mineral Resources to advise that they do not wish to address the Commission on the application for a postponement, but that they make common cause with the other state departments which oppose the application. Coming then to our own submissions, we submit that it's fundamentally important to distinguish between two related but very different questions. The first question is whether it is desirable that the injured and arrested persons should be legally represented before this commission. And most of the argument which has been heard this morning has been about that, has been the contention as to why it is desirable that the injured and arrested person should be represented before this commission. In order to avoid any possible misunderstanding, I'd like to make it clear that it is the view of the evidence leaders that it is desirable that the injured and arrested person should be represented before this commission. We don't wish to comment on whether there's a legal entitlement in that regard. That's the matter which is before the High Court. But we would hope that there's no doubt about the view we take as to the desirability question, which has been debated at length.
The Constitutional Court itself gave its views on the matter in paragraph 15.
Has almost said the same thing. However, that is not a question which this Commission has the power to decide. This Commission doesn't have the power to order the State or the Legal Aid Board or anyone else to fund legal representation for the injured and arrested persons. The question of the desirability of representation before the Commission is simply not before the Commission and never has been before the Commission, and it is not a matter for decision by the Commission. It's a matter for decision by various state bodies, by various private bodies, and in the final analysis by the courts, and it's being fought out in the courts at the moment. So that's the first question, and one needs to park that question and be clear that that's not what is before this Commission at the moment, the desirability of representation. The second question is the matter of what is before the Commission, and that is this: what should the Commission do while the injured and arrested persons are continuing their efforts to raise the funds for representation? That's the question which is before the Commission, and that's the question on which this application for postponement turns. Not desirability as a general principle, but what should the Commission do while the injured and arrested persons are pursuing such remedies as they have to raise funds for representation. That, with respect, is the real question before the Commission. And we say that there are two possibilities in this regard, two possible options. One possibility is to stop the proceedings while the accused and arrested persons continue their efforts. And we need to be clear in practical terms, not in theoretical, but in practical and actual terms, what that would mean. First, at the very least, it would mean a postponement for a month, because the matter is set down provisionally or otherwise for the 25th and 26th of September, and there's no reasonable prospect that the matter could be decided before in the High Court in less than a month from now. So it means in the first instance, on the most optimistic scenario, a postponement for a month. Secondly, it means in all probability a postponement for a longer period, because in the light of the application which has now been made for amendment in the High Court, it's very unlikely that the matter can be heard on the 25th and 26th of September. There's clearly going to be opposition to the amendment. The amendment will have to be decided. The permissibility of the amendment will have to be decided, and only then will the main case be argued. and there may have to be further affidavits filed. So the amendment proposed creates the virtual certainty, I'd say, that the matter can't be heard on the 25th and 26th of September anyway. So a month is hopelessly over-optimistic.
Of course, there's a further point that even if it is heard, the judge obviously will have to deal with substantially more matters in his or her judgment than would otherwise have been the case. And that the preparation of the judgment may accordingly take much longer than would otherwise be the case, which the date in respect of which to which the application relates is not the date when the matter is heard, but when judgment is given. And of course, the longer that the delivery of that judgment is delayed, the longer will be the period.
That's right, Chair. So we have a minimum of a month on an optimistic assumption, which is now plainly an unrealistic assumption in the light of the amendment. And then there's a further difficulty, Chair, and that is that when the High Court eventually decides the matter, whenever that will be, the one thing one can be certain about is that there will be an application for a second postponement by whichever party has been unsuccessful, just because it will want to pursue an application for leave to appeal and whatever appeal rights it's got. One can be certain that Mr. Mpofu's clients, if they lose in the High Court, will want to appeal it. And one can be equally certain that Mr. Oosthuizen's clients, if they lose in the High Court, will want to appeal it.
Yes, but to be fair, Mr. Mpofu did say, in response to a question you asked before, that this application is for a postponement up to the date when the High Court gives judgment and not thereafter. And he accepts, as I understand it, that if he loses in the High Court, the postponement, if he gets it, will come to an end while he's pursuing other remedies in other courts.
That's not what the point I'm addressing, Chair. The point I'm addressing is I'm saying there will be an application at that stage. There will have to be an application. Assume the postponement is granted. This postponement. The inevitable result is a second application for a postponement when everybody comes back here after the High Court has given judgment, because whoever loses is going to want to appeal. And at that stage, having granted this postponement, there will be no postponement. There will be no sensible basis in which you can say, oh no, we won't grant a second postponement. We'll allow a postponement for the High Court to decide, but we won't allow a postponement for the Constitutional Court to decide. That, with respect, would be incapable of justification. So you have to understand, we submit, the road we're going down. The road we're going down is that if this application is for postponement is granted, there will be a second application for a postponement after the High Court has given its decision, and there will be no sensible basis on which the Commission, having granted the first postponement, will be able to refuse the second postponement. And so it's, with respect, a never-never situation that we're looking at. We are looking at the most cheerful, I'm an optimist by nature. The most optimistic assertion I can make is that if the High Court hears the case not too late after the 25th and 26th of September, and if the High Court gives a reasonably early decision, and if the appeal procedures are then done very quickly, and if there's a quick decision by the Constitutional Court or the SCA thereafter, even my optimism tells me that can't all be done in 3 months. That's the reality of what the Commission is looking at, and that's why I'm asking the Commissioners to consider the practical consequences of granting the application for postponement now. This is not a matter of a few weeks. A few weeks are serious enough, but it's a matter of a long-term postponement. Add to that, Chair, the fact that the point to which you referred when Mr. Mpofu was addressing the Commission, that now that one of the remedies sought is a declaration of invalidity of a statute, the matter can only be decided ultimately by the Constitutional Court. Or let me put it differently, that relief can only finally be granted by the Constitutional Court. He cannot get, in other words, he cannot get the relief he seeks without a decision of the Constitutional Court. So at least a two-stage hearing is inevitable for him to get the relief which he now seeks.
That's the alternative.
In the alternative, yes. So all of that suggests that if the postponement is granted now, the Commission is going to effectively be binding. It's not binding itself, but the logic of the situation is that there will be no hearing for several months until the High Court has heard it, or whenever it hears it, until the next leg takes place. And so that is the difficulty that we have with a postponement, granting the postponement application. If you ask Mr. Mpofu, correctly I submit, said last time this was raised, he said that ultimately there's a question of prejudice. Well, the question of prejudice, we need to see what the facts are. The facts are a very long postponement. Then we say, so what is the prejudice? Because that's the test. What prejudice will granting the postponement cause? We submit that there will be very considerable prejudice to the public, who will be kept waiting for an outcome which is a matter of compelling national importance, and for which many feel they've already been waiting too long. There will be another delay of at least several months before any outcome can be achieved. We submit that there's a further prejudice that the result of the findings of the Commission may be that certain remedial measures have to be taken, whether it's by the police or anyone else. If those measures need to be taken, it's in the public interest that they be taken sooner rather than later, because there is always the risk, if things go wrong once, they can go wrong again. So there is considerable, there is an urgency in achieving whatever remedies are the outcome of the Commission. And thirdly, there is a prejudice in that this is, at its heart, an exercise in accountability. And one of the elements of accountability, of effective accountability, is some promptness. Accountability, which is in the history books, assists nobody. And the need for accountability and for prompt accountability is a further matter. So we submit that the prejudice of granting the postponement is very considerable. It is assuming that the President extends the term of the office, the term of the Commission for a long period. It is the prejudice caused by a very long delay in the findings, caused by a very long delay in any, the findings which are a matter of public importance, very long delay in any remedies, and a delay and an undermining of accountability. By the time these things happen, people have left office and they can't be held accountable. So that's the prejudice for granting the postponement. We say it's very material, particularly given the length of the postponement. If it was a day or two or three, it would be different, but this is a long postponement which stares us in the face. Then on the other side, what is the prejudice of refusing the postponement? And that was not really addressed or explained in the application, because we've heard of the prejudice which is caused by people being unrepresented. But as I've tried to show, that's not a matter which is before the Commission. What we're talking about is the prejudice caused by the absence of legal representatives of the injured and arrested persons from now until legal representation is provided. That's the prejudice, because the postponement is that there should be nothing should happen in the interim. So it's prejudice in the interim caused by the absence of it's prejudice caused by the absence of representation in the interim, and one has to say two things about that. Firstly, the absence of representation may be permanent. I hope it's not, but it may be. But secondly, assuming that there is representation provided in due course, what is the prejudice caused by the temporary absence? We submit that if the postponement is refused, the Commission will continue to hear evidence, and if the legal representatives for the injured and arrested persons later return, they'll be able to ask to cross-examine any witnesses who've already given evidence in their absence. They will have access to the running record which is produced on a daily basis, and they'll be able at any time to say, well, General Mpembe gave evidence, we would like to cross-examine him. He was cross-examined, but he wasn't cross-examined on the following matters, he wasn't cross-examined adequately, or we want to address the following matters. Please call him back for this purpose. Colonel Scott has given evidence, we didn't have the opportunity to cross-examine him. Please call him back for the following purposes. And there'll be, if there's a need for them to be further cross-examined, the Commission will allow it. And so the prejudice is not a prejudice in inability to cross-examine. It's prejudice caused solely by a delay in cross-examination. That's the only prejudice. The sole prejudice which is caused by a temporary absence is that the cross-examination by the injured and arrested persons will be delayed. That's it. No other prejudice has been pointed to, because they can cross-examine at any time and they've got the record. And so one can fully understand, as I say, we've been told repeatedly and forcefully that the injured and arrested persons will be prejudiced if they are not represented before the Commission. And one can fully understand that argument, but that's not the issue. The issue is what is the interim prejudice, and the interim prejudice is solely a delay in the exercise of whatever cross-examination they may undertake. And so we submit that the only question left before the Commission is what should happen while the injured and arrested persons are attempting to obtain funding. I've made, to summarize, that if the Commission postpones, at the very minimum for a month, more likely for 3 months, while they're attempting to obtain funding, there's very considerable prejudice to the public interest and considerable prejudice to the country at large. Conversely, if the Commission proceeds and the legal representatives are returned, there is no material prejudice to them caused by the postponement. The only prejudice is the delay in their cross-examination of witnesses who have come. And so we submit that the short answer to the question identified by Mr. Mpofu, which we submit is correct. He said it at page 13092 of the record. The test is the test of prejudice. We agree with that. We say the only possible answer to that question is that however sympathetic one may be to the claim to legal representation, and we are sympathetic, that cannot justify a postponement because the prejudice is overwhelming on one side and very, very limited, if at all, on the other side. And so we submit that what the Commission ought to do is to get on with a job which it has been given by the President and for which the public is anxiously awaiting an outcome. If the funding is found in due course, which we hope will be the case, application, and if on any other basis the legal representatives of the injured and arrested persons return, they can make application for any witnesses they want to cross-examine to be recalled. In the meantime, we'll be able to make progress, and the Commission will be able to do the job which the public waits and expects us to do. Thank you, Chair. Chair, may I make one other thing, draw your attention to one other thing. There's been an affidavit submitted by Mr. Iser, who represents part of the Baku community. They have stated that they oppose the application for postponement. The other... You've seen that application? The administrator says that he abides. Yeah.
Thank you, Mr. Bartlett. Mr. Mpofu and Mr. Mosikili, which of you is going to speak first?
I'll go first, Chairperson. Chairperson, with the greatest respect, once again, I thought maybe it was just a deficiency in the papers. But once again, we are hearing a lot about expediency, and nobody has addressed the question of the effectiveness of the outcome.
Do you really mean expediency? Or you
rather, I'm sorry, expedition. Sorry, I'm making Mr. Nsebeza's mistake. I didn't mean to be facetious about it. Expedition.
I thought it was a slip of the tongue. I was just giving you
it was, yes. No, thanks. Once again, that's all that's been addressed, which is really where we started this morning. So there's been no improvement. Nobody has addressed the question of whether or not the outcome will achieve the intended outcomes of the establishment of the truth and justice, among other things. He has finished, get on with it, as Mr. Butlander says. But to what end? This can't just be a sprint to the finishing tape. Surely it must be about achieving something in the distance. And a hollow, expeditious finish really means absolutely zero. And if what is being postulated is that the interest of the public is that they would have spent up to now, according to the minister, 115 million rand has been set aside for this commission. All that money could be wasted if the outcome is hollow. So expedition on its own is meaningless. I'll start with Mr. Badlander's submission because there's a specific issue that I want to raise where he says that the issue of legal representation is not before this commission. That cannot be so. Regulation 8 of the terms of reference of this commission says any person appearing before the commission may be assisted by an advocate or an attorney. So, firstly, that right is the other side. They will come here, of all places, to ask for a postponement. That will never happen. On what basis could the president and the minister, if they are the losing party, come here? Yes. So it's just a monster that doesn't exist.
But Mr. Mpofu, the prejudice that you complain of now will still be present if the matter is decided and one of the parties decides to go on appeal. That prejudice will still be there after the High Court judgment if it's taken on appeal.
No, how will it be there, Commissioner, if you can assist me?
If you lose, you won't be able to come back here. The prejudice to your clients will still be there. If you win and the other side takes it on appeal, that's not going to translate into an immediate representation for you here. So that prejudice still remains. So there is a further period that is envisaged by the appeals.
No, it's not. That's not automatic. In terms of Rule 4911 of the Supreme Court rules, which have just been changed, so whatever the equivalent now. In terms of Rule 4911, it is possible that the judgment, whether there's an appeal or not, the effect of the judgment, the impact of the judgment, the execution thereof, which is that funding will be granted, will take place. And I can assure you now that's exactly the route we would take. So it's not God-given.
Put it straight. If you win and the other side appeals, then the application for leave to appeal, or the appeal, will suspend the operation of the judgment unless you apply
in terms of Rule 4911
operation.
Correct. Thank you.
It's not as absolutely clear, perhaps, but there's certainly a possibility.
Yeah, possibility I can accept.
We won't go there.
I'll accept the possibility.
Even if you win, you won't get legal. You won't get funding immedately.
I can't
if you lose, of course, then you will appeal.
Yes.
But you've conceded that the postponement you seek will not extend beyond the date on which the High Court will give its judgment.
100%. I agree with that. And I'm happy to live with the possibility, but it must not be presented as an inevitability. That's all I'm saying. That that further period will necessarily eventuate.
But Bundles made another point. He said if you lose, then the probability is you'll come back here and ask for another postponement pending your exhausting of the appeal procedures. Now, are you resisting that submission as well?
Yes. And I'm resisting on the following basis, Chairperson. You can't deny a postponement now because there's some theoretical possibility that at a later stage there'll be another postponement application. That postponement application will be dealt with on its own merits. It will have its own dynamics, its own periods of probable postponements. What we are dealing with here now is a postponement of the number of weeks it's going to take to come back here, win or lose. But how could you, what if this monster never eventuates? Then will they have denied the postponement now because it could possibly eventuate with its own. What I've committed to is that I will come back and if I come back, if one of the, and I accept that one of the possibilities of that I would come back with would be that. I might be coming back and say the clients have decided they've done enough and they're no longer going to participate or whatever. I don't know what the instructions are. What I'm saying is that it can't be decided on some speculative basis of what or might not happen at that stage. Yes. Or there might be private funding that would have been obtained. I might come back and say, Chairperson, we have private funding until the end of the year, and we'll see what happens in between. I mean, who knows? So, with respect, well, we're not scared of the scarecrow, let me put it that way, because it might not happen, yeah. And I suppose I'm taking a favorable interpretation. If it's the short postponement that we're asking for, and not the long one that's postulated by Mr. Badlander, then I suggest that you grant it on the basis that we've asked for it. Then I'll just go very quickly back to what other people have said. Mr. Berger, unfortunately, is not here, but I think he misunderstood what I said or did not read it properly. All I said, which is true, and which I repeat, is that in our opening statement, we referred to the issue of the toxic relationship. And that is true. The opening statement is there. Ms. Pillay is not here. She would tell us which exhibit it is. But all I was saying is that that's what it says in our opening statement, that it alleges a toxic relationship. And I was saying that in relation to the fact that, on our version at least, then those parties who are parties to that toxic relationship are represented by 12 advocates as opposed to 1. And the reason why, which covers Mr.
The complaint was raised, he had 2 complaints. The one about the toxic relationship, he said what he had to say about that. But he said the number was wrong as well.
I'm coming to that.
He said, and he gave the numbers, which were not the same numbers as the ones you gave.
Right. He didn't give any number. He gave numbers that vary from 2 to 1 to 3. This is the situation. The people who were here, when I said remember what I said, Chair? I said you appointed the evidence leaders, they appointed their counsel, and they appointed their counsel.
Say those who read the transcript won't
I'm sorry, yes.
You're pointing to counsel for the SABC.
For the SABC, and then
the SABC appointed their counsel. You then point to the direction of the London Council, they appointed their counsel.
Yes, that's why. So whether the number fluctuates from this or that is irrelevant. All I'm telling you, Chairperson, is that these are the people, when they got the brief, they appointed the following 5 counsel. Mr. Berger SC, Mr. Bam SC, Mr. Mutau SC, Mr. Van As, and Mr. Shozi. That's 5 in my book. So that's the situation. What happened to this one or that one in between, and whether today there are 2 or 3 is mightily irrelevant. Now, then, Chairperson, the Constitutional Court judgment, unfortunately, has become a matter of a lot of debate. Firstly, clearly the remarks that were made there were obiter in relation to the main application, and I won't even go to explain.
I made that point for you.
You did, but the bigger point that you made.
You made it better than I did. Carry on.
Yes. No, Chairperson. Another point which you made for me, which I'm also going to repeat, not because it's better, but because I think it's still misunderstood, is the sentence in paragraph 11, which says, our consideration of the High Court's finding must not, however, be seen as anticipating the outcome of the main review application in the final relief sought. 2 things that come out of that. One, they don't anticipate the issue of prospects of success. Secondly, is that they view the main application as a review application already, even before the amendment is made. So by referring it to as a review application, it vindicates the fact that the amendment simply codifies what is, at least in the eyes of the Constitutional Court, already a review application. Secondly, when it comes to the other issue of that Mr. Badlander referred to, of the constitutionality, that is not going to delay. Firstly, as I say, that's an alternative, well, as the Chair pointed out. But secondly, a declaration of constitutionality is not money, is not funding. So the outcome of that particular declaration, whether it favors us or not, is not going to determine whether we come back here. It's got nothing to do with it. It might influence someone to decide whether they give funding or not. But it on its own has got nothing to do with whether we come back or when we come back. And in any event, just going back to Mr. For what it's worth, Mr. Oosthuizen's suggestion that that particular amendment is not canvassed in the papers, that means he probably has not read paragraph 73 of the founding affidavit, which says, to the extent that it may be asserted that the hands of the respondents are tied by the absence of the legal framework which encompasses commissions, I am advised that it will be argued that the Legal Aid Act is to that extent unconstitutional. This is so, firstly, because it would amount to an irrational differentiation between commissions and other independent and impartial tribunals and fora, and secondly, because it would be manifestly unjust and unfair. Alternatively, the legislation ought properly to be interpreted in such a way as to avoid all the said injustices and inequities. That's the basis. It's already in the papers. There's no need to supplement the papers. And by the way, the issue of irrational differentiation is a basis for the other amendment, which is the review. The review is not done in terms of perjury. So let me just disabuse them of that. It is on the basis of the irrationality test that's postulated in cases such as Batu Star and the rule of law. But that's another debate for another day.
Mr. You've got 10 minutes left. I don't know whether you want to give some of it to your colleague, Mr. Muskili.
Well, Chairperson, if I'll give some of it.
I don't know how much more you've got to say, but I'm just alerting you to the time considerations we did agree beforehand, which I've been
then let me just
varied in your interest.
Yeah, fair enough, Chairperson. Let me then just do this so that I can prioritize Mr. Oosthuizen's contributions. The part that I read from Losa, which he says does not apply to procedural fairness, does. Unfortunately, I started in the middle of the paragraph. The part that I did not read says, while the extent to which requirements of procedural underline fairness apply to investigatory bodies might be uncertain, there is no doubt that these requirements do apply to commissions appointed by the president or a provincial premier. So that's that. The rest of the passage that I read earlier then applies. So it's exactly about procedural fairness. And then the next point, Chairperson, very quickly, is that the considerations of fairness, which Mr. Skidi also referred to, should be and are ingrained in the accepted, even internationally accepted procedures for commissions such as this one. The so-called Salmon principles, among others, say the following, and this is now on 172, paragraph 172 of Losa. Lord Salmon, yes. In his report, he gave 6 requirements, but in Losa 172, same para 172, Chairperson, same, yes. And C, I'll just refer to 2. C of those, it says the cardinal principles laid down by Salmon Commission have for 1, 2, 3, which is C. Such persons should be given an adequate opportunity of preparing his or her case and being assisted by legal advisors. That means the participants. And F, I'm jumping again, F, such persons should be given the opportunity of testing by cross-examination by his or her advisor any evidence which may affect him. That covers it. And even Sir Richard Scott, who criticized the Salmon principles, changed them around, but this is one of the ones that he retained. Yes. No.
When he was, I think.
When he was still Sir.
He was still in the High Court before he was.
That's correct. He rearranged the summary principles, but this is what he retained. D, under his rearranged ones. Legal assistance should be available to those involved, both at the stage of giving evidence and at the stage of responding to criticisms, which will be probably an argument at the end. So, any commission that does not even comply to those internationally accepted principles cannot be fair in the sense that was intended by those things. Chairperson, there's a lot of material. I just don't want to leave out something that's important. Oh yes, Mr. Matibedi. I think I just have one thing to say to him, and that is that if his high regard for the evidence leaders, which he says should present the version of the the parties that are actual, let's put it that way, which I share, then why is it necessary for him to remain here, him and 6 others, to remain here to represent the interests of SABC? Because then what's good for him should be good for the others as well. The only reason, if I may venture to answer my own question, the only reason is that he knows that in addition to the highly respected evidence leaders, the SAPS is entitled and is exercising its right to have its own counsel to make sure that in addition, and that's what we're asking for. We're not questioning the evidence leaders or their integrity or competence, none of that. But we're saying, like all the other parties, in addition to the evidence leaders, the applicants that I represent are entitled to have their interests represented by their legal representatives. So it's cold comfort for SABC to say, rely on the evidence leaders, but we will stay here, all 7 of us, and assert those additional rights. Thank you, Chairperson.
Mr. Muskili, I think you've got 5 minutes, but I hope you won't need more than that. But do the best you can with the 5 minutes, and then we'll take stock.
I'll be very short, Chair. Indeed, that's right. Chair, just to respond quickly to Mr. Van Oosthuizen's submissions. First of all, as the families, our clients have not withdrawn, and I think we need to clear to state that correctly. Our clients have not withdrawn from the commission. They still remain interested, and what they have done is simply withdraw their instructions for us to be here to the extent that we are here today. But they remain much part and parcel of the commission, and they are still interested in participating, if obviously and when they feel that the conditions are so conducive. Secondly, the issue of prospects of success for funding. Chair, we simply submit that is not the test for this postponement application. It is not for this commission to be bothered with the prospects of success. And the third point, Chair, is the public interest. The public that we engage with, our client, Chair, we know that they are interested in the continuance of the commission, but they are more interested in their taxpayers' money funding both the SABs, to extend that is funding the SABs and funding the lawyers for the arrested and injured. So it is not simply correct to say that the public's interest is only to see the commission being at least completed expeditiously. That is simply incorrect. And then, Chair, to the submissions by Mr. Mutibeni, to an extent that if I heard him correctly, that he suggested that why don't we represent, seeing that we all get along, I suppose, why don't the families of the attorneys for the families represent the injured and the arrested? Chair, our submission is simply that suggestion is untenable, simply because we all know that those who are arrested and injured are arrested for the exact murders of our clients. So it is untenable to suggest that, Chair.
I'm reminded that that's not quite what he said. He didn't say you must represent them. What he said was, you can call them as witnesses so that their version can be put before the commission, and presumably if you have their version, you can then cross-examine witnesses who come and give evidence which is contrary to their version. I think that was his submission, if I understood it correctly.
That's correct, Mr. Chairman. And also I said making available information or evidence available to them.
Yes. So if you, by all means deal with his submission, but summarize his submission correctly before you deal with it.
Chair, indeed, I did say if I heard him correctly, and clearly I didn't, Chair. But even that alone, Chair, it might cause some conflict, but I don't want to go down that route, Chair, for now. And then, Chair, on Mr. Butlender's submissions, Chair, on whether the the submission being that you should not be inclined to give postponement because there's a possible postponement, the issue of double postponement application, Chair will submit that, Chair. That is not the test as well, Chair.
That point was argued by Mr. Mpofu. I don't know if there's anything you want to add to that. He made that point, I thought.
Chair, what I want to add, Chair, is this, Chair, is that another possibility, what might happen after the High Court. It might well be, Chair, we don't know, that the arrested and the injured, they approach us and they say, families, we fought a good fight, but you go back. We go back and be our eyes and our ears for as long as we are out. And that might not necessitate another postponement. I'm just putting another possibility, Chair.
Get funding.
Chair, the question really that Mr. Butlender also put again was that, which I understand is that, is it desirable for this commission to continue while the arrested and the injured are seeking funding? Chair, the answer should be no. While we accept, Chair, that there might be a day that, as undesirable as it might be, where the Chair would not have any powers but be forced to continue with the commission. As things stand, Chair, you do hold the power to do something about it, Chair. Whether it might yield to any results, but it will send a message out there, Chair. Chair, just lastly, this case, as has been argued, Chair, it goes back to our point that we raised, Chair, that our clients are also concerned with, which is that this boils to poverty and those who can afford legal representation. And it is, according to those, Chair, that I represent, that in their view, those who are not poor are here inside the commission. Yes, they might have been funded or might be funded by Legal Aid Board, but unfortunately they do see themselves as poor. And Chair, it is sad, Chair, that again we are here, Chair, and we're dealing with the issue of poverty, that poor people are being denied access. And that, Chair, that just takes me to the quotation by Nelson Mandela, Chair, where he said, when dealing with the issue of poverty, saying that overcoming poverty is not an act of charity, rather it is an act of justice. Like slavery and apartheid, poverty too is not natural. It is a man-made and it can be overcome and eradicated by actions of human beings. Chair, it is that action that we require you, Chair, to take, to say, I am going to hold this commission for now and give these poor people a chance, at least to have a last shot probably, at the High Court, whatever the result that might be. I thank you, Chair.
With your permission, I promised I'll just want to make 2 quick points which arise from...
They're quick.
Yes, they're very quick. The first one, Chair, is the issue of kind of surrogate representation by the families of the deceased. It's in practical, it's contained in a letter which we wrote to the Legal Aid Board. If you remember, that's the suggestion that they made as one of their rational reasons why they wouldn't fund us. And we traced to them the history of why it was that we did not represent any of the deceased persons which Mr. Musikide has dealt with. And it is because we could not represent their the murdered people and their alleged murderers at a particular point. So that's a major point which could never, that conflict, at least insofar as those charges are provisionally withdrawn, still remains there. The last point, Chair, is that there's this assumption that the status quo now is fair. Our argument has been from day one that the current status quo, where the injured and arrested are represented by one advocate, is itself skewed and not something to be encouraged. And part of the effort we're making is to ensure that there is, if the time comes, whether because of a court order or whatever, there'll be a day where we can sit down with the powers that be and ask for assistance, not for 7 advocates or 5 or whatever, but 1 or 2 people who can assist, so that the current unfairness is not perpetuated where one person has to do all these things. As it is right now, I have to rush back and file the heads of argument, which could have been done if there was someone else assisting. So it's not as if it's a happy situation. It's already unfair. We're just saying we don't want it to be irreversibly and completely, the outcome to be completely discredited. Thank you, Chair.
We will take time to consider our ruling on the application for postponement. We hope to be able to give the judgment, or the ruling, it won't be a judgment, it'll be a ruling, at 9:30 on Monday morning.
Mr. Chair, may
Yes.
I ask, with your permission, that myself and Advocate Modisa be excused from Monday morning. We will have our junior here to note your ruling.
Yes, no, we'll be sorry not to see you, but we excuse you. We'll adjourn now until 9:30 Monday morning.